Hi viewers, welcome to part one of Ben Gray's video documentary expose called Judge Alexander Ralton, the Demon Butcher of Bristol. My name is Ben Gray, as I say. I'm a freelance journalist living here in East Bristol, where I've lived for the last 20 years, and my intention with these videos is to expose the most egregious forms of corruption it is possible to perpetrate or imagine in terms of criminal proceedings. This part one is called of Judge Alexander Ralton, the Demon Butcher of Bristol, is called The Incident and Prosecution. Part two, which will follow obviously part one, is subtitled The Civil Trial. And this obviously involves the actual proceedings before Judge Ralton, after proceedings in the criminal court had failed against me when I was prosecuted for a Section 5 public order charge. This documentary, much like it's the Barbarians at the Gate, which is my other documentary in terms of events of the 30th of November 2021 that occurred at Bristol Crown Court. This documentary originated from an incident sort of on College Green and inside the Bristol Central Library, just off College Green. The events which unfolded were recorded by me, and in a moment I'll show you the footage of the incident that occurred on the 10th of February 2015. This involves my interaction initially with two community support police officers, Mr. Dumble and Mr. O'Neill, and they say that I'm banned from a library, and I'll present more evidence after the video, but in simple terms, there was an incident on the 5th of February 2015 in which a man who went with a German accent, I don't know if he was actually German, but he thumped into me with a large sort of sports bag that he had on the side of his on his side, and as I was working on a computer in quite an open area of the library, he smashed into me, caused me quite a lot of pain, gave me considerable shock. I was at the time in my late 40s, and I got up to remonstrate to this man that he'd assaulted me, and he clearly must have known that he had impacted me, and he responded by saying loudly he was going to chop me up into little pieces. Which some of the other library users found amusing. I then attempted to detain him whilst police came on the scene, and two police officers turned up. One of them, I think, was called PC Jackson. Unfortunately, I didn't keep good records of that incident, but in simple terms, the male was allowed to leave, the male that I had apprehended and effectively citizens arrested, and there was going to be no further action with the complaint that this man had assaulted me and effectively made threats to kill. Certainly used words that talked about chopping me up and into little pieces. So seriously, the more serious element was obviously the physical assault, but followed by clear evidence that he deliberately assaulted me by his deeply offensive and upsetting comments that he was going to chop me up in front of other people as well, and potentially causing an affray, which he did do, because obviously then I had to use some sort of degree of force, although I don't think I held him very firmly, but I think I might have held onto his bag. I'm not entirely sure given the passage of time. But these officers just dismissed my complaint and treated me, as they always do, as the villain of the piece, as the culprit, and the library staff did likewise. I later received, not long after the incident, a letter just prior to the 10th of February saying that I was now banned from the library due to my conduct, my behaviour, being aggressive, and making victims of the library staff in some fashion, and I'll read out the letter after we've seen the video. But that's the backdrop to having been banned by the library. I am a job seeker, so I need access to the computer to search for jobs. I wasn't online at the time, so I was entirely dependent on access to the computers to continue signing on. also it was completely wrong, because I was the person who was attacked. There was no dispute. Otherwise, clearly, I would have been arrested on the day. There was no evidence from the police that I'd made things up. The CCTV would have easily caught the man thumping into me, but of course, CCTV is either deliberately destroyed and lost, as we saw with the Barbarians at the Gate video, and you'll see in countless other videos, or it's just not looked at altogether and just dismissed as of any significance, especially where it's Ben Gray who's complaining of being violently attacked in full view of the CCTV cameras. That is a running leitmotif through virtually every incident I've ever had with the police and the courts. So because I foresaw some sort of public order issue, and I was going to address the issue of this Mr. Harris banning me without being witness to the incident, without validating what evidence he'd looked at in terms of video footage, without giving me a right of response. This is almost identical, you will see, from Sharon Boreham's, who's the court cluster manager at Bristol Crown Court, or for Bristol and Gloucester Crown Court, who had banned me over an incident which had been filmed again, and before I'd given an account of myself, or without any interest in who had actually said what or done what. So all the worst aspects of the allegations are treated as fact by Sharon Boreham at the in 2021 incident, and this is precisely what staff, senior staff, do in virtually every issue that I have, whether it's at job centres, court buildings, and in this case, libraries sort of effectively run by the council, obviously this incident was foremost in my mind when I was attending the library to challenge the so-called ban. When I attend, what you will see on the video unfolds. Unfortunately, my camera holding isn't very good. I'm obviously caught up in extremely stressful confrontation with the police, a confrontation which I say they instigated from all perspectives, because I should have mentioned, of course, the police enforced the ban. They're not interested in whether the ban is justified, or the fact that the other police had already been involved and were refusing to investigate the threats and the physical assault from the male on the 5th of February. And it's, in any event, it's a civil matter. They said I would treat it as a trespasser, but of course the only way they can enforce trespass is by way of an injunction or some kind of court proceedings. They can't just arbitrarily, if people are trespassing on any private land, it's not of itself a criminal offence and a civil matter, unless there's some other issues of crime involved in the trespass. But so yes, the camera is not held very well, and you have to excuse that. And also, there's a problem technologically with the sound being in sync with the action. So the action is out of sequence with the sound recording, which does add to the confusion. But obviously, what's most important is the sound recording and the words that are exchanged between myself and initially with the first officer I speak to is Community Support Officer Dumble, which is an appropriate enough name, and a little bit more from O'Neill, but mainly with Dumble. And then I go into the having been told that I'm banned from the library, I ignore the ban and go into the library, and then I just have endless confrontation with the police, and we'll watch the video. I'll shut up and I'll come back to show you what unfolded and the degree of corruption and collusion that eventually unfolded before Judge Alexander Ralton.
Hi there. You go? Yeah, I'm Mr. Gray here.
Are you Gray?
Yeah, I'm Mr. Gray actually.
How you doing?
Yeah, I'm not so bad. So basically, you've been given all the details, so I don't have to. Is that playing?
No, it's not.
I was going to say, is it probably not a good idea? I've got a lot of allegations and findings about assault from Avon and Somerset Police.
Yeah.
I mean, I can film you, obviously, but is it not a good idea you also film me to avoid any allegations?
I can do if I want to, but I'm not at the moment.
Why are you not doing that? So that you can give me a good walloping and then say that it was...
That's
all
ridiculous thing to state.
Is it?
Yeah.
Why have I got findings of police having assaulted me then in the courts?
I don't know about your
No,
past.
but you do, because I've just told you, haven't I?
No.
Unless you're accusing me of lying.
I don't know about that past.
Are you accusing me of lying?
No, I haven't done that.
Then you do know about it because I just told you, don't you? You do. Look, ask them. Call headquarters. Call Superintendent Richards.
You're not allowed in this premise. You're banned. You're not allowed in there.
Okay, and who's going to stop me? You.
Pardon?
Who's going to stop me? You. Who is going to stop me? Security. Are you simple? All right. Okay. So you're not going to be involved until it gets to that issue, right? Because you know there's going to be.
Not to go in there because you're not allowed in.
No, you initially told me I was banned. Okay.
Yes.
So what is your role in the ban? Are you the henchman for the library or what? Because trespass is a civil matter, isn't it? It's not a police matter, isn't it? Why aren't there any police? Why have I got just PCSOs here?
That is police.
Are you?
Yes. Yeah.
Are you the same as a police officer?
No.
Beg the question why you're not wearing a police officer's uniform.
Police officer. The first word in my job title is police.
Okay, all right, you're police. All right. So I mean, go on. You advise me. You're giving me some advice. You're saying that
I'm advising you to leave the area. Do not go.
To leave the area.
Yeah. Do not go in there.
Are you some kind of fascist Nazi to tell me where I can and can't walk in a free country, in a free city? Is that your role? What is your name, officer, please?
Only the places you banned.
Only the places I'm banned?
Yes.
And who has the authority to ban me? Can I ban you? What's your name? Can I ban you from this area? Are they civilians?
It's aggressive, isn't it?
I know.
I'm aggressive. I've got two yobs in the bully. Let me just check out your boots with your big bully boy boots on, telling me I can't go to various areas of Bristol when I've hurt nobody. So who's the aggressor? You're coming into my face, aren't you? You didn't have to come right into me. Well, you were in your car, okay? You were in your car. You were in your car, so how come you're now 3 feet from my face? Okay, if you're not coming into my face, have I come into you? Have I come into your face? Huh? You need to talk to me? Alright, well you can talk to me from a safe distance. Please explain to me what authority, under what rule of law, you are telling me I cannot go into the library.
It's not a law, it's civil.
Exactly. It's a civil. It's not the police. You are not the henchman for the civil issue between me and them. Otherwise, I could get police to do all kinds of civil action on my behalf. Okay, that is not the way the law works. If they've got a civil grievance, they go to the court. If they want to keep me out of the building by way of civil remedy, then they go to a civil court and get an order. They don't get on the phone to a couple of uniformed thugs to come and intimidate me and terrorise me. You are thugs. You are. Who are you to tell me I cannot walk into the library if not a thug? You look pretty thuggish. With respect, you look pretty thuggish.
It's not a very respectful thing to say, is it?
What? That you're thugs?
Yes.
How else would you describe? How else would you describe yourself? How else would you describe yourself? I'm minding my business. I called the police in advance of my coming here, out of good faith, because I want you to be able to protect me if there's going to be a civil incident. Okay? You're now making it clear that you're not going to protect me. You're actually going to take their sides and enforce a civil ban.
I told you you're not allowed in there. That's it.
Oh, but are you the civil courts? You already accepted a civil matter. So how do you? All right. Well, you've already made your peace. So I'm going in there. Okay? Now you haven't advised me. You gave me an order, so don't start lying. Yes, I've got you on film telling me not to go in the library. That's not advice. That's you giving a fascist order. Yes, it is. Believe me, you're not the henchman for the local management at the library. Believe you me, they don't just pick up the phone and say send round a couple of yobs to terrorise Ben Gregg. You've already accepted this as a civil matter. So what are you doing getting involved with the prevention? If that's a civil matter, you explain that to me.
You've been advised not to. As you are banned.
Am I banned? Am I banned?
Yeah.
You see, you're coming right into my face. You're coming right into my face. No, I'm not. You already. If I stop suddenly and turn around, and there you are, 1 inch from my bottom, that's you getting into my face. You creep. Okay. Here you go. You got your henchman now. You got your henchman. Where's Mr. Harrison? Okay, let's not put the money where the mouth is, okay? You are not going to terrorise me, you're not going to harass me, and you're not going to abuse me, and you're not going to get the local henchmen like this is the 1950s to take care of me. You're the one who created this issue. It's not with these people, the issue is with the management who send the letter out. Let them put their money where their mouth is and send them down here.
Finished?
I haven't even begun. I could be here till 6:30 or 7 o'clock, and I'll be back here Monday, Tuesday, Wednesday, Thursday, Friday. I told PC Andrews, or Jackson rather, that I would come back here if I got a letter banning me. I'm more likely to come here if I got a letter banning me than otherwise, and they were quite prepared to deal with the matter then. Did they arrest me? No. Had I committed any offence? No. If I committed an offence on the 5th, that is the so-called ban, they would have arrested me on the day. They've accused me falsely of assaulting some bloke who's just minding his own business, walking down this aisle here, just where we're standing. In fact, he assaulted me, he walloped me with a bag, in plain view of loads of people. He then said he was going to chop me into little pieces at the top of his voice. Okay? So if I had, and then they've now sent me a letter saying that I've assaulted him. Okay? So if I had assaulted him, why didn't the police arrest me for assault on the 5th? It's basic common sense.
I don't know anything about the 5th.
No, exactly, you don't, nor do they, nor do even the management who have banned me. They weren't there, only the people who were involved in that situation, and certainly PC Andrews, who was there on the 5th, knows about it. They came and told me, the other officer, not Jackson, he said, we have a witness to prove that he didn't hit you. And I said, where was this witness? They said, the other side of the table at the other screen. You can see that's the table there, the screen where I was sitting, where that bloke is now, here, with the glasses here on the far, that's where I was sitting. Nobody can see what's going on with that person on the other side of the aisle with two computer screens.
They decide to ban you. That is what it is.
No, it isn't what it is. I'm sorry. What is it? Well, I'm here. Do I look banned? If it was as simple as that.
Well, you are banned, but you breached that.
Oh well, we can take up the breach. Look, you know about civil law, right? That's what you're professing to be the case, okay? I've won numerous cases in the civil court, so I know a little bit. How many have you won?
How many have I won?
Yes, how many cases, civil or criminal, have you won?
Well, it's not my job to win cases specifically, is it?
No, but you're giving me advice on what the law is, about the civil law or the criminal law, okay, aren't you?
No, we're not. We're advising you.
What?
To not come in.
But you're saying, you're saying that the power or the authority.
No, I'm not saying that.
Well, so you don't care whether there is any authority to ban me. You're just saying it's your job as henchman to act for the ban.
No, I'm not a henchman.
What?
Saying no.
Well, tell me what your role is here. You're here as legal advisors, are you? Well, why do you keep advising me about the ban? That's the civil matter between me and the library.
I'm advising you to stop causing a scene, breach the peace, and.
I wasn't causing the scene. I said that I would cause a scene. I said that if you're not going to protect me, I'm certainly going to get the person who's imposed the ban.
What do you need protection from?
From the people that have assaulted me. I've told you like 1,500 times. You're not even a police officer, so.
That's got nothing to do with the situation.
Of course it does. The matter. Believe you me, the only way this matter is going to be resolved is through the criminal courts, one way or another. Okay.
Why does that need to happen?
Okay, well we can stand there. That's fine. We can argue legal sophistry all day. You can stand there with your. You can stand there with your arms folded. Don't keep walking towards me. That is a mistake. All right. You keep taking steps. This other person here is okay. What are your names? Are you going to give me your names? That would help to diffuse it, wouldn't it?
Diffuse what exactly?
Diffuse any potential, so that you're not anonymous people in neo-Nazi outfits. You actually got names. No, they look pretty ugly to me. Okay. I've seen too many shots of. Have you seen Ian Tomlinson wearing exactly those uniforms, killing a poor man who's just walking down the street? Once you get into those thuggish outfits, you start to act in character that uniform promotes. Of course you do. Of course you do. And most of you are completely uneducated. You even put the O levels to your name, and you're given huge power. And then you get the power and the stupidity mixed into one, and it's a lethal combination every day of the week. Why are there 15,000 complaints in the last month against the? I'm judging them. I'm judging from my own experience. That's the only way I can judge you. I didn't say you were. Listen to what I'm saying. I said most of you. Most of the frontline officers don't have an O level to their name, and those are statistics. Of course they are. Of course there is. Anyone with remotely a qualification goes up straight up through the ranks straight away. Yes, of course it does. Of course it does. Oh no, you've got geniuses working on as police front officers. They're famous for the PC. There's no such thing as a PC blot in the English language, is there? You're famous for your acumen. The frontline PC brain power is famed throughout the world. Okay, so I'm falling into line with your dream. Your fantasy. All right, you're clearly very bright. I'm sorry, you blinded me with your. So where do we go from here? Well, I'm happy to be here all day. So yeah, no, exactly. So let's. Unfortunately not. I wish I could. Honestly. All right. Well, you can give your evidence in court. Okay, it comes to the trial. Okay. Well, do I want an ugly thing like you coming in my face? I mean, I've never. Get your fucking hands off me! Get your hands off me!
You'll get arrested.
Will I arrest me then?
That's what's going to happen.
Go on, no, arrest me now! No, am I under arrest? You cannot put your hands on me unless you're arresting me. No, you can't! I know the law backwards! Believe you me! You cannot put your... Okay, you are arrested.
Yeah, you're under arrest.
Are you happy now, girls? Are you happy now? Are you selling his boss?
So there we have the video. I've shaved a little bit off the end because because you can't see what's going on, and I am effing and blinding at officers or potentially library staff. I'm not entirely sure, because obviously the passage of time again, and because there's no visual recording. There would have been CCTV, but of course that was never seized. So unless it's clear what's actually going on, I try to avoid any allegations or any evidence that can't be backed up. And obviously it's because I am using offensive language, obviously not in the context that I'm using it in a breaking the law sense, but there's no need or necessity for me to put it on. It doesn't assist any party in terms of this matter. But apart from that, what you see is obviously what I've recorded, but as I say, with the sound and visuals out of sequence. Well, what are the legal issues there that I hope any UK citizen or somebody from basic Western civilization generally would agree that my Article 5 human right to liberty and security is being completely flouted. I am being criminally harassed by Dumble. He's made it quite clear he doesn't care about why the ban's in place, whether it's justified or not. He doesn't care whether it's simply a civil matter. He's just going to simply abuse the fact that he was wearing a uniform. He doesn't care about the fact that a male only 5 days before had threatened to chop me up into pieces and smashed into me, obviously deliberately with a large sports bag. And the potential danger to the public that person would be generally, merely with enforcing the ban, like as though he has any legal authority to harass me and prevent me to involve himself in a civil dispute about a civil matter between two civilians, in which no offence or criminal offence is involved, or suspected criminal offence. In terms of a breach of the peace, there has to be. As again, I go into more detail because I wasn't arrested for it, but obviously the officers do have the power to prevent a breach of the peace, to make arrests if there's an immediate breach, but that has to involve violence or threatened violence, and clearly the only issue of violence was my complaint about violence used against me on the 5th of February. Without any further issue, the police are already breaking the law. They're already flouting my right to be liberty and security, to be protected and not threatened with, as Dumble's really doing. At one level, he's clearly threatening me. He's using his uniform and saying that it's his role to say that I'm banned and that I'm not allowed in a court building. Clearly under some sort of threat of at the least being harassed by him, or the worst, some form of violence, which is obviously what I'm bearing in mind. I've been found to have been falsely imprisoned at this stage on 4 previous separate occasions, in terms of findings or admitting by the chief constable that he has falsely imprisoned me in 2007, and then found to be falsely imprisoned in 2008 by the criminal courts, and then found in the civil courts to have been falsely imprisoned in 2010, or twice in 2010, and then a further false imprisonment. There's multiple evidence of other false imprisonments, because every time a British citizen, or certainly a citizen from England or Wales, is arrested, presumably it's the same as Scotland, the presumption is that unless they've been convicted, then the onus is on the police to justify arrest. That is the ruling of Hicks v Faulkner. It's long established in proceedings. It's been mentioned in proceedings in which, by judges themselves, in proceedings in which I'm involved. So the 30 or so other arrests, which I haven't been able to litigate because of a civil proceedings order put against me at the moment by Judge William Davis, or Lord Justice William Davis, as he styles himself. And then before that, there was general civil restraint orders, including during the issues in 2015, which we'll come on to obviously when we deal with Judge Ralton. So obviously the fact that I've been falsely imprisoned, never mind, and the fact that I can't litigate if the police do feel like falsely imprisoning me, which they do on frequently, then obviously I'm going to be even more intimidated by these threats from Dumble, this threatening behaviour from Dumble, these warnings not to breach a ban, and. By the time, obviously, I've been continually harassed by these officers and intimidated, they've escalated the situation so that I can't, which I intended to do initially, speak civilly to the library staff. And I just simply, I protest about the ban and the fact that the ban was made, and I explained to officers and to the library staff that the ban was made because I was assaulted, violently assaulted by an anonymous person in 2000, only 5 days before. This then escalates, and then we have PS Sean Underwood turn up, who is effectively the person that decides to arrest me, and well, not effectively, he was the person that decides, a few minutes later to arrest me. And when I'm engaged in what is clearly a heated, volatile situation, a female library user comes right into my face, inches from me, and starts to tell me to take it outside or take the argument outside, as that she knows as though there aren't two people involved in the argument. Indeed, the police themselves interjected themselves into my life, into my attending. I called the police. It is true to say that I would be complaining very vociferously about the raising merry hell. I think I might have said because of the fact that I've been assaulted and terrorised by a male that the police and the library staff were not only colluding in but making me out to be the culprit of. Was clearly a matter that I was going to address by any means. And of course, I couldn't go to the police station because I immediately get bent up or attacked by police officers there. So those are matters for other documentaries. But the female has that comes directly into me and tells me to take it outside. Again, is only aggravating an already volatile situation. She's accusing me of being the instigator when obviously there was me and several police officers involved in the argument, and the matter was for the police to resolve. That is why they get involved. They generally do not expect civilians to do their work for them and say whether somebody and tell somebody that where they should be. Of course, on what basis is telling somebody that they should leave a building who's another civilian not harassment? That is not the role of that female, other than to harass and to stir up an already volatile situation. And I said, why do I want an ugly thing in your face, or words to that effect, in the heat of being involved in a terrifying and unpleasant situation with the police that this female could clearly see, and whether or not I was referring to her looks or what I thought of her looks or her behaviour or a combination of the two is utterly irrelevant, because she's the one who's harassing me. I'm well within my rights to have an opinion, a personal opinion about somebody who's involved themselves in who's harassing me. There's no dispute that the harassment begins with the police, begins with Dumble and O'Neill. And by the time I've got involved in an altercation, an argument with them, when PS Underwood turns up, he's obviously on their side. And again, it's me that's instigated everything. Everything has flowed from me, not from the originally with the German-sounding male 5 days before, and the police collusion in that, which is the only reason I've had to attend the library at all or be banned because of the police collusion. And I'm being made the scapegoat, as usual, by everybody all concerned. And whatever misunderstanding that this female, this anonymous female, because we never got her name, even though she was the basis of my then being arrested. So you can hear what I say. It's not the nicest thing anybody's ever said, but it's perfectly fair comment within the context of what she's doing to me and what the police are doing to me and what the library staff are doing to me and were doing over the period of the 5 days. And then we hear Underwood, and it wasn't disputed at trial. It's clear on the footage although you can't see it, you can hear from the sequence of the sound recording. He grabs hold of me. I remonstrate with him that he has no right to arrest me or to grab hold of me, that he hasn't said you're under arrest. And I said, I shouted, I know the law backwards about this, because I do, because I've been arrested and won claims in the courts, and therefore I'm familiar with the basic law powers of arrest and the circumstances of arrest. He didn't say he was going to arrest me, and he clearly can be heard saying, if you continue, or words to that effect, if you carry on, I will arrest you. So after he seized me, he then threatens that he's going to arrest me at some point in the future if I don't fall into line with his with the behaviour that he wants me to exhibit, for whatever reasons he has about that. That is clearly under the authority of R.V. Wood, which I'll come on to in more detail again when we come to the case before Judge Ralton. But that is an assault. An officer that does not, who grabs hold of somebody, and in my case restrains me, and it doesn't even have to be a restraint, but in my case I think I don't think it has to be a restraint in general, but in my case it was, physically depriving me of my liberty by grabbing hold of my arms, when he's clearly admitting that he's not arresting me, that he will arrest me at some later point if I continue with my behaviour. So that's clear cut. He hasn't grabbed hold of me for the purposes of arrest, and that is That is the definition of an assault of a police officer, abusing his powers of arrest when he's not arresting somebody, but actually restraining or in some way violating that person's right not to be manhandled or grabbed hold of by strangers in or out of uniform. So he's then put me in manacles. He's cuffed me. He says, "Yeah." Then he says, "Yeah, he does arrest me." And moments later, he carries out the threat of arrest. He puts me in manacles rear stack, which is when your hands are obviously behind your back, with a great deal of force, putting them tightly onto my wrists, and then manhandles me out of the library, and I'm shouting, I've now got an audience of the library staff, including a lot of the females that were involved in colluding in the assault on the 5th, who just stirred up the whole thing. They clearly, they probably had looked at the CCTV, or they certainly should have done, given a complaint about being hit with the bag by this man. They'd stirred the whole thing up. And I sort of say, are you happy now that you've achieved your ends, ladies? I'm then taken outside to a police car, and I'm bent backwards over the police car, and I'm not supposed to be. You see, the whole issue of Underwood is to bellow, "Calm down, calm down." Obviously, if you twist somebody up, if they're already the aggrieved party, or feel that they're aggrieved party, they're already involved in some kind of issue of which that officer knows nothing. And he's bellowing at you, "Calm down," while twisting you up with handcuffs, in which your only response is to angrily complain about being tortured, which effectively is what you are, humiliated in front of the entire, effectively treated as a slave, like some sort of Greek comedy, where the slave is the naughty slave that gets carried out and manacled off, as though this is like the 1850s. And not only that, he then bends me back over the van, or the car rather, and straddles my left thigh. And I can clearly I can clearly feel his genitals pressed against my thigh, and causing me untold humiliation and fear and degradation. All for an issue that didn't involve any allegations of violence from me. He says that he restrained me in this way, when there are a million other ways to restrain me, because he was to protect another officer that was present who never gave evidence, called Inge, which apparently was his name, a PC Inge, although I don't know his full name, and who was massive in of itself. Underwood is a very large, obese male, and larger than me, much larger than me, and Inge himself was very large. And there was no suggestion that I was resisting arrest or attempting to assault an officer, but he said he had to restrain me in this extreme way. And even if he had to restrain me, because why the other officer wouldn't be involved in that restraint is not explained, and clearly proves that Underwood is fabricating that version of events. And this went on for a couple of minutes whilst I could feel his genitals being pressed continually against my thigh. And I've still got my rucksack on as well, so that's pulling back against my handcuffs and causing even more anguish, pain and humiliation. And this stayed on with the handcuffs in place until I actually got to Patchway Police Station. And eventually the handcuffs are taken off me and I'm presented before a police sergeant, Wilshire. I'll play you some footage now, and what you'll see is my being presented at the custody suite about an hour later after my arrest at the library, or 40 minutes or so later, and I'm presented before Police Sergeant Gary Wilshire.
They are fading. If I could just, you said that there are indentations.
I would document. If you're making suggestions that there is marks on the handcuffs, have you seen by the nurse?
I don't want to be seen by nurse, but I mean, these are the kind of injuries that...
I will anyway. Show me a wrist.
No, I don't want to see the nurse. I mean, if you're going to detain me on Section 5, I wouldn't advise it, because you've done that before and I've successfully sued you, but if you're going to detain me on Section 5, do it.
You're showing me your wrist, Mr. Gray.
Yeah, that's what I want to do. I don't want a nurse, and you can't make me see a nurse, I know that.
I don't like you, no.
No, exactly, so there's no point in wasting any wisdom on that, but all I'm going to probe is these indentations there from the cuffs. I can see there and there, and that's all I want to register that. Bearing in mind it's Section 5 arrest, not assaulting an officer, it might possibly justify that.
What are the circumstances?
We were called to Bristol Central Library by some police community support officers who were trying to deal with this gentleman. Because he'd been banned from the library. The behaviour I saw was shouting very loudly. This was distressing members of the library. I was asked to calm down. He continued shouting at a female customer, I guess, of the library.
So they're shouting out?
She was shouting generally at all of us. And then a female member of the what do we call her, customer, I guess?
Teacher?
Yeah. Came up and asked him to leave because he was distressing everyone within. At that point he told her to off.
I didn't. I was filming it. Remember I filmed it. I didn't tell her to fuck off. That's just she was fucking ugly or something or other.
So he was arrested, Section 5 public order.
So I think I said I didn't want a fucking ugly face coming into my face.
Criminal matters is no further action. Oh, they're trying to not further action. But the previous one is there. It's in about us, yeah.
Made a day because I got a smiling afterwards.
Yes.
When the officer explained to me,
Could you speak up a bit because I'm having trouble with this?
when the officer explained to me the grounds for your arrest,
Yes.
and he said that you were abusive to the lady and sort of football, I believe he said, I didn't say that. I believe I said, yeah, I think I'd be paid back to one.
Something along those lines.
Maybe he just signed to say that's what
No,
he
I'm not saying. I mean, this has been sound recorded. You've got me bound to right.
I'm just bound to offer you the opportunity to sign for something. I'm recording
Yeah,
on the
I've always, just for the record, I mean, you probably will ask me about other things as well, but I'm advised by lawyers. One of the advice that lawyers have given me that I've followed is never sign anything unless there's a lawyer present.
So there you have it, viewers. Just compare and contrast the video recording of the entire incident, which still hasn't been viewed by the time I'm in custody and before Sergeant Gary Wiltshire. And the footage is out of sequence, as I accept. It's blurred and I'm moving around a lot. I'm not catching any clear images for most of the time because of the distress of the situation. But all the sound is crystal clear. And you can hear at no point do I use the F word. At no point do I shout at any other member of the staff before I'm arrested, or the library users per se. I mean, I'm talking loudly, I'm not shouting, but whether or not it's shouting or talking loudly, I'm talking directly to the officers. When the female, the anonymous female, so let's just call her Anonymous F, for female that is, when she approaches me, although she's directly coming to my face, although she's harassing me quite clearly, telling somebody to go somewhere else when they're having an argument that may well or almost certainly was being caused by the other party, and certainly Anonymous F doesn't know what the basis of the situation was, which was the 5th of February attack, collusion in the attack by the police, and then harassing me from entering the library after the attack on the 5th of February 15. So that was the basis of my upset. This lady does not know. All she knows is there's some heated incident between myself and the police. It is for the police to deal with. That is why they are police officers. She's not a sort of a temporary police officer to start sorting out a public order issue. Clearly, if I was committing any kind of threats, this Underwood accuses me of threatening library users or other people in the library. Absolute fabrication. And indeed, if I was being threatening in any way, given my size, this female would not have directly approached me and then start harassing me about where I should go. And my response to her is, in an absolutely quiet, measured tone, initially just saying it's got nothing to do with you, and calmly pointing out that the situation is in hand by the police and not her concern. She continues to harass me, and I respond by saying, I don't want an ugly thing. Well, why do I want an ugly thing coming in my face? That is a perfectly, in the stressful situation, it's not a nice thing to have said. It's mildly offensive, and as I later argue, but it's irrelevant really, given what she's doing to me and what's happening to me in the general. I'm talking about her behaviour. Her behaviour is ugly, and it's up to her to interpret what I'm referring to. But I don't want her in my face. I happen not to think that she's very attractive, and I should choose, whether it's physically or by their personality, I should choose who I want to engage with, unless I'm doing something to offend them or assaulting them. And I was nowhere near her. She came and approached me and offensively, and I would say illegally, harassed me. But there's certainly no effing and blinding going on my part, and I'm certainly not shouting at her. But Underwood, even though he knows it's been recorded, trots out this most vile and villainous fabrication in front of Wiltshire. He claims he didn't know me. He needed to arrest me to find out my identity was one of the reasons. Obviously, there has to be reasonable suspicion of an offence to do that. I would suggest that even if he didn't know me before, bearing in mind I've called the police, I've already had an argument with them about my having to attend about the incident on the 5th of February. And when Underwood is involved, he's had plenty of interaction with the police before he turns up, about me, about my situation. So at some point between when he initially became involved, I would suggest, and certainly when he's in front of Wiltshire, he knows that don't worry, the barristers and judges, or the former barristers at Albion Chambers, now judges at Bristol Crown Court, with whom Ben Gray has been involved for the last by that time a good 10 years, and they'll let any bit of perjury go. If you any excuse to bend up Ben Gray or falsely imprison him or shut him up or oppress him or terrorize him is grist to our mill. We soak that up, and if you want to perjure yourself away, this is the message that I'm suggesting has been passed down by the judiciary. But what other explanation is there? The offence of perverting justice, of making false allegations, carries up to life imprisonment, and it can be any situation. And I put the ruling up, or brief summary of the authorities on perverting justice. But it's quite clearly making up false allegations to even to possibility of having an innocent person arrested amounts to perverting justice and is an indictable criminal offence. In my case, I've already been detained, and this officer is simply fabricating after the fact basis for arresting me in the first place by saying that I've used the F word towards members of the public in a public library, and that I've been shouting at them and I've been threatening at them. Every single one of those assertions is absolute fabrication, and the officer knows that it's going to be proven as a fabrication from the recording of the incident. When I interrupt him and I say, actually, that's a lie, remember it's being recorded, I actually say, eventually say, when officer says, the original version of Underwood, and obviously you have to keep track, but at the time he's in front of the officer, in front of the Sergeant Wiltshire, the key words that he says is like, I told the female to fuck off. Absolute perjury, an absolute false allegation from start to finish. I interrupt him and say, no, I actually say, what do I want a fucking ugly thing like you coming in my face? And the F word that I'm using there in the description of what I've done in the past is, well, first of all, I'm extremely distressed about being arrested, and I'm trying to present the calmest possible, because what these officers want, the more any aggression from me or any evidence that I'm carrying on some kind of public order issue gives them an excuse to bend me up. It gives them more incriminating evidence to put in the court, and it potentially gets me a chance of being left in cells for a long time. So I'm trying to calm the situation, present the most calm demeanor, and trying to be as sort of as ironically distant from the situation as I can, both for my own sake and also to keep myself calm, and also to create a calm presentation to Sergeant Wiltshire and gang. But I point out that, so when I say why do I want an effing thing like you coming in my face, is the F word that I'm using in that at that time could as easily been when somebody uses the F word in their normal speech, rather than I'm actually quoting from myself at the time of the library, but I'm saying I didn't effing say that, I effing said that. You're using the F word as to denote frustration in the fact that Underwood is lying, and that what I actually said was something else, and the F word is to denote the frustration, not to quote me directly from the incident. The point is, it's open to interpretation, what I'm saying, and to some extent that is deliberate. I'm leading the police on. I've got somewhere in the back of my mind that I've got. You have to just a little bit to recap. It's important to point out that although the last thing I want to do is be arrested, that is the last port of call I have to get these matters before a criminal court, because I'm subject, as I've made clear in my other videos, to what's called a general civil restraint order at the time, and now it's a civil proceedings order, which is completely covers everything from litigating in bringing private prosecutions to civil litigation of any description, which I'm banned from doing now for the duration, courtesy of Lord Justice William Davis, who's the latest Lord Justice to become involved in these cases and these issues. But at the time, I was subject to what's called a general civil restraint order, which still meant I couldn't litigate in any civil court. So the police are given, this is basically a fatwa, as I've made clear in my other videos, that allows the police to do anything they like to me, knowing that they're not going to be subject to civil litigation, and except if I'm prosecuted in a criminal court, in which case, obviously, everything is fair game, including my allegations that I'm subject to judicial conspiracy under the criminal offences of judicial misconduct in public office, which is clearly established in common law, R.V. Llewellyn-Jones, R.V. Bembridge. These are well-established authorities where judges, for any major misconduct in public office, have been, although low-ranking judges, but all judges are susceptible to that criminal offence. So I can say that the general civil restraint orders is directly leading to the conduct of Underwood. But in any way, how are they going to deal with me if they can't put me in, they know I can't litigate them, but on the other hand, they know that in order to litigate me, I have to go in front of a criminal court, and in theory anyway, that criminal court has to be judge is independent, and they'll, of course, we'll see that they're anything but they still have to prosecute me, and it still has to come out into public proceedings, and therefore it's not like it would be in the civil court, a slam dunk where they just get a corrupt crony judge to rubber stamp preventing me litigating at all, and just allow everything to go on behind closed doors. I mean, most of my incidents with the police do not even lead to prosecution, so it just leads to me being bent up, often injured, left in cells for sometimes for 20 hours before being released, and then the matter's NFA'd down the line, and it never gets into criminal court. In this case, as we shall see, it goes all the way to criminal court. Then they even rebut civil. I am, for one brief moment in history, allowed to litigate, in which case I bring the claim surrounding this matter, but let's not jump ahead of ourselves. The issue at the moment is obviously why Underwood is the fact that Underwood must know that he's committing major criminal offences that carry up to life imprisonment by lying, fabricating the fact that I'd shouted, etc., and effed at this woman and called her a bitch. Although he doesn't, and effed at her and so forth. So. And I won't refer to it because I have to relive the whole interview. So I've only shown you the bit of the initial reasons that Underwood gave for detaining me. But another point, and it's mentioned in forms anyway, that I complained that I've been sexually assaulted by Underwood in terms of him straddling my thigh as part of the arrest that we discussed earlier, in terms of the alleged lunge at an officer Ings, Josh Ings, as we later clarified his name was. So, but notwithstanding I've made the serious allegation, nothing is done in terms of my investigation, or at that time in terms of investigating Underwood for the sexual assault. He's allowed to have conduct of the case even after I've been initially charged, and then subsequently that there is an investigation into what happened at the library by Underwood himself, bearing in mind he's already, I've accused him of lying in front of Wilshire about telling this female to F off, and indeed everything, the threats, the shouting at library users, certainly before my arrest. So in terms of the justification for arrest, none of the conduct, the incriminating conduct that was spelt out by Underwood, in being recorded doing it under CCTV sound recording, was true, just completely fabricated in order to justify bending me up, indenting my wrists with these handcuffs, humiliating me, causing me major anguish and degradation, and so forth. So we come on to the next stage of, therefore, the investigation, or the initial investigation. And we deal with Underwood's, all the various statements that are made in relation to the incident, and the continued litany of fabrication and perjury. I mean, in many senses, I could leave the matter there, because simply the recording of Underwood lying about what I've done, any person with the basis bit of common sense and knowledge of right or wrong would know that Underwood's that by lying to justify detaining someone of their he's not only lying to detain me of my liberty at the time, to prevent, deny me my liberty and restraining me at the time, and that's what the lie is to judge. It then is used to prosecute me and to continue with the prosecution, even though, again, the footage has been seized by the police, and they know that they're going to examine the content of the SD card inside the camera that I've used to. So actually an MP3 player, with a camera attached, and he knows it's going to come to light that he's lying in his teeth about everything about the criminal conduct towards the library clients and staff. And we'll come on to what he says in the MG5, bearing in mind the MG5 is partly investigating himself for his own conduct surrounding the incident, the altercation, including, because obviously the fact that he's detained me and what I say after I've been detained, including in some regards incriminating myself, although it doesn't matter if the matter's been recorded, so it doesn't matter. I could say that I'd made threats to kill or something, and it wouldn't matter if the sound recording proved I didn't. I maybe get in trouble for making false allegations against myself, but it's irrelevant what I say, about the I mean, what's more relevant is obviously Underwood lying when he told Wiltshire that I told the female to F off. So we have now what's called an MG5 statement. This is composed by, in this case, Underwood himself, with his supervising officer, Dave Layden, Inspector Dave Layden, who we know nothing about. There's no information that was given later on in his proceedings, even though it went to both criminal court and civil court. He was never mentioned as a witness in any respect, and he's got no online presence at all. So we have no idea who Inspector Layden is, except that he's authorised the investigation to be conducted by Underwood, which must be illegal anyway, bearing in mind that I've accused Underwood of sexually assaulting him. So he desperately wants to, it's important, given the sexual assault allegation on top of what he's done is actually kidnap me. I mean, I didn't sort of stress that early enough in the earlier part of the documentary, but I may have done, but he's kidnapped me, he's assaulted me under the ruling of Wood v DPP, and therefore he's absolutely desperate to make something stick, and to think up anything that comes into his head. And Layden should have known that, and therefore not have appointed Underwood, because Underwood's clearly breaking the law, even in terms of his having to be independent from the thing that he's investigating. No man can be an investigator in his own complaint, or a judge in his own case, which effectively is what he has to do as an investigator. So the inevitable consequence is that he then incorporates he not only does incorporate, he actually embellishes and increases the amount of fabrications that he gave Underwood about the conduct that led to my arrest, or rather the alleged conduct that led to my arrest. So this is the MG5 statement from Underwood and Layden. Key evidence. On the 10th of February 2015, the defendant called police stating that he had received a letter from the library stating he was banned. He stated on the call to police that he was going there to create merry hell and shout the place down, as he needed to use the library to search for jobs. Police community support officers were asked to attend at the library and make sure all was okay. Police community support officer Dumble and O'Neill attended and did see the defendant outside the library. They asked him not to go in as he was banned, but the defendant just ignored this advice and went in. Whilst inside, the defendant was again asked to leave by the PCSOs, but again he did not take this advice. He was becoming more and more aggressive in his tone and shouting inside the library, causing a disturbance. The PCSOs called for police officers to attend and try to calm the situation down. Well, I'll just briefly pause there, because there's two massive lies, there's two glaring evidences of perverting justice right off the bat. For a start, there's no mention of my counter-allegation or the unresolved, uninvestigated investigation into my complaint that on the 5th of February, only 5 days earlier, I had been attacked, physically attacked, and then threatened to be chopped up into pieces, with witnesses, including one witness, I'm going to come to her in due course, who's a library member of staff who witnessed me being some of the altercation with the German, or presumed German chap, anonymous 2 as we should call it, because we've got anonymous 1, the female, and we now have anonymous 2 in terms of I never found out the name of the person that I alleged had attacked me with the bag and then threatened to chop me up. So that's clear fabrication, because that's clearly mentioned in at all stages in the altercation, to PCSOs, when I called the police on the 999, and so forth. And the second issue is on what basis is just taken as read that it's perfectly acceptable for these officers to approach me, get right in my face and say, you're banned from the library, as though it's anything to do with them. It's a civil matter. It's not, cannot be enforced by police. We do not live in a police state that is controlled, because effectively the library is run by the Bristol City Council. The council, of course, is a democratically elected civil organisation. It is not. They are not a tier of the general Avon Somerset Constabulary force. It's really no different from, it's simply civil trespass. And civil trespass, that when you walk onto a farmer's land, for instance, and you don't have a right to be there, they cannot forcibly remove you because you're not committing an offence. You can't be restrained unless you're actually going for the purposes of some ulterior criminal. There's evidence that you're going there for equipped, i.e. to commit a burglary, or armed to commit an assault. But if you're just on committing civil trespass, the only way it can be enforced is through civil orders through the courts itself. And it's just taken as read that these officers, what they're actually doing is criminally harassing me, exploiting their uniforms, exploiting their position of power to terrorise me because of all the bad faith I have with the police surrounding other litigation matters. So to continue with the MG5 statement, as police arrived, they entered the library and could see the defendant stood with raised arms and shouting very loudly. The public library was full of people either on the computers or reading. All were looking at the disturbance and looked shocked. Police approached the defendant and he was asked to calm down. Again, this advice was not taken and the defendant continued to shout. A member of the public, a female, then approached the police and the defendant, a member of the public, this is an anonymous one, a member of the public, a female, then approached the police and the defendant, and she asked the defendant to leave and shout somewhere else, as it was disturbing and distressing those trying to work. With this, the defendant opened up a torrent of abuse, shouting very loudly and aggressively. He finished off saying to the female, "You fucking ugly bitch," at 16:50 in quotation marks. At 16:50 hours, the defendant was arrested for Section 5 public order. He continued to shout over the arresting officer and now shout abuse directed towards the police and anyone else around. The defendant continued shouting and swearing the whole time. He was led outside to the nearby police car. The defendant continued to shout and swear and was told to calm down on several occasions, as there were now a lot of children in the immediate area. There was not a single child from start to finish. It would have been their fault, the police's fault, for torturing me and kidnapping me anywhere, let alone in the middle of central Bristol where there could have been children. There were certainly other civilians that were caught in, because the whole altercation, even the anonymous female getting involved in the first place, was the fault of the police for harassing me and invading my rights. Of course, I should have mentioned, of course, that I have rights to liberty and security under Article 6.5. The police are supposed to exist to enforce the rights of British civilians, not abuse them. And they're clearly abusing my rights to liberty and security by threatening me and demanding and ordering me because in the form it stated as advised to not to go in and so forth, but of course they were ordering, so that's another fabrication in the statement. Fairly minor, considering we're now on to fucking ugly bitch, I've now said to this female allegedly, which has even changed from the evidence that Underwood himself gave the previous day, because I think this was made the 16th, the 11th of February, so this was the day before, and now he's changed the allegations to even more serious abuse, where I've called her ugly and a bitch, which wasn't mentioned in his original version of events. At 16:50 hours, the defendant was arrested for Section 5 public order. He continued to shout over the arresting officer and now shout abuse directed towards the police and anyone else around. The defendant continued shouting and swearing the whole time. He was led outside to the nearby police car. The defendant continued to shout and swear and was told to calm down on several occasions, as there were now a lot of children in the immediate area. He was then conveyed to Patchway Custody Unit, where he was detained. Whilst conducting the booking in procedure, the defendant stated, "I didn't say that. I believe I said to get her fucking ugly face out of mine." He refused to sign this on the custody record. At 10 hours, the defendant was charged as he now stands before the court. So the Underwood's completely frank. he's the casual manner in which he's carried out this investigation doesn't mention the fact that there was footage and that I was filming. He doesn't mention anywhere that's yet further fabrication, because he doesn't mention the fact that I'm holding a camera and the whole incident is recorded. And that I told him I was recorded. When he quotes from me, he doesn't quote himself, saying that he originally told the sergeant that I told the female to F off, because he's excluded, why I've interrupted him with my version that is itself potentially false, because I've incriminated myself a little bit, or there's some ambiguity about what I'm saying. But the officers just changed that anyway. But of course, he doesn't mention the fact that it's recorded. Indeed, not only does he not mention it, but we'll come on to part 4 or section 4 of the MG5 statement, which deals specifically with VRE, which is video recorded equipment. This is where, given that so many incidents involve some sort of digital history, usually CCTV or body-worn video from the police officers or private mobile phone footage, etc. So it's actually incorporated into the forms that the investigating officer has to include in the summary, which is what an MG5 is. It's a summary of the key evidence and key facts of the case. And here, very straightforwardly, the section 4 says visually recorded evidence is there VRE, to which Underwood puts yes. If yes, in quotation marks, does it provide key evidence? And to which Underwood says rather bafflingly, no. Give details of what it shows, whether key or not, and include tape counter reference times for relevant key sections, i.e. defendant punching victim, kicking window, etc. And then Underwood has put, it only gives post-arrest footage. Well, that's a complete fabrication. We've just seen, and I've showed you the footage that the police themselves eventually disclosed, which was downloaded from my SD card, which shows the incident beginning with my interacting with Dumble. So long before I've come anywhere near even engaging with the female in question, and everything is recorded, including the female engagement with the female, and then some bits of post-arrest. Underwood is just simply, not only is he because he's had to lie about why he's arrested me and lie to incriminate with this bundle of filthy lies, which he then increases by saying that I've actually called her a fucking ugly bitch rather than just told her to F off. He knows that the only way to deal with that is to now lie that he doesn't have any video footage of the actual incident. And of course, the lie is so grotesque that it's not clear if he's claiming to have looked at the footage, and therefore he would have known that it contained the whole incident, including the key issues in terms of what I said to whom prior to arrest. Or has he simply not looked at the footage because he doesn't want to, perhaps even tell himself the extent to which he simply lied about my engagement with other members of with other users from the library. And he signs it off, and it's signed off by Dave Layden, who's supposed to be overseeing and ensuring, in particular, that officers, Underwood, he's supposed to be ensuring that Underwood wasn't even on the case because of the conflict of interest, and then ensuring that the officers, dotted all the T's, such as looked at film footage and so forth. And of course, the fact that he doesn't mention anywhere in the initial statement, because he doesn't mention anywhere in the statement that I'm filming, he's tying that in with his point at part 4 of the MG5, where he claims that that I only filmed, or that the film only came on post arrest. So again, not only the mere absence of him saying that I was filming the incident is clearly to pervert justice. He's doing an act which is concealing the commission of an offence to direct an investigation from its proper course. That is the very clear-cut perverting justice criteria to form a case by which somebody can be indicted and indeed convicted. This is then put before the CPS to progress the case to trial on the basis that I've shouted, threatened members of the users of the library, and told, and in particular, which obviously formed the basis of the arrest itself, to either F off, depending if it was that version, or that she's an effing ugly bitch, which was the later invention of Underwood to justify arrest. And of course, Underwood provides witness statements, sworn witness statements that he has to, that is included in the original information. I shall be. The statement each sign. This is what anybody who signs what's called an MG11 or Section 9, which is a police statement of any evidence taken from either a police officer or anybody else involved in an incident which is being investigated. Each signed by me is true to the best of my knowledge and belief, and make it knowing that if it is tendered in evidence, I should be liable to prosecution if I have willfully stated in it anything which I know to be false or if I do not believe to be true. So he signed his name to the statement, and I'll read it out. This he made on the day of the incident, the 10th of February 15. I am Police Sergeant 3851 Sean Underwood of Avon Somerset Constabulary, currently based at Bridewell Police Station. On the 10th of February 2015, I was on full uniform duty, and at about 16:45 hours, I was called on the radio to attend at the Bristol Central Library on Deanery Road, Bristol, to report a male who was in the library and becoming aggressive and abusive towards the police community support officers. Upon arrival at the front door, it was a little unclear where they were, and after a couple of minutes, it was discovered that they were in the main room of the library. I entered this room in company with PC 1414 Kevin Parsons. Upon entering the main room, I could see a male I now know to be Benjamin Gray, 11/7/1966, who had his arms in the air, and I could hear raised voices. As I approached, I could see the library was extremely busy with loads of people either reading or on the computer. The room was in a large square room full with shelving and books. Yeah, well, most libraries are full with shelving and books. Thanks for that absolutely irrelevant detail. This area was slightly raised to another room that seemed to have more computers with people sat at them all. There was a few steps leading down to this area. At the top of the steps was where Gray was. Most of those in the room seemed to be turned and looking at the obvious disturbance Gray was causing. Well, I'll just interrupt myself there because that's complete bias. He has no idea who's caused the altercation. He's only just arrived. God knows what it was. He had been told on the radio, but at the worst, it was shouting. Am I shouting to something in response to something? Well, clearly I am, because I'm surrounded by police who had arrived to meet me. And of course, there's the issue of my having to relive being attacked by the assault on the 5th of February. So again, just absolute glaring and unvarnished bias from Underwood, which is what you'd expect considering he's illegally investigating in the first place. Stood in front of Gray was PCSO Nathan Dumble and PCSO Luke O'Neill. I got close enough to Gray and he was still shouting. I asked him to calm down, to which he just continued to shout in a very aggressive tone that we couldn't do anything. It was causing obvious distress to all the members of the public I could see using the library, who were all looking at him in what looked like a shocked state. Gray would not calm down, he was just shouting. I then saw a female approach from the other side of the library and got within 5 meters of Gray. She quite clearly told him to leave as he was causing a scene and distressing people trying to work. At this point, Gray just opened up with abuse towards the female. I cannot recall the exact abuse in full, but it was along the lines of she had nothing to do with it, and I do recall him telling her she was a fucking ugly bitch, in quotation marks, and had nothing to fucking do with it. At this point, I was extremely concerned for everyone as he was getting so aggressive. I approached him and took hold of his arm to usher him back away from the female. He was still shouting. As soon as I could, at 16:50 hours, I said to Gray that he was being arrested for Section 5, public order. I arrested him to prevent further offences, ascertain his identity, as at this stage I had no idea who he was. As soon as we were outside and away from the immediate area of members of the public, I cautioned him, to which he continued to shout abuse at me over the top of me. He was still shouting and then also shouting at me, calling me a fucking fat pig and various other abusive comments, all extremely loud, with many members of the public around the library. He was so loud and abusive, and it felt like he was trying to pull away from us at this stage. For the safety of everyone around, including Graham himself, I placed handcuffs on him at the rear and escorted him outside. Gray continued shouting and abusing most around him, when outside officers were continually asking him to calm down, but he just wouldn't. When outside and close to the car, I tried to search Gray under Section 32 of PACE, to which he continued to shout and abuse me. I asked him to calm down as there were loads of young children around and they did not want to hear his foul language as this did not stop him. At this stage, I noticed we had been joined by PC Josh Ings. As I was searching him, PC Ings tried to calm him down. At this point, it felt like Gray lunged forward and came face to face with PC Ings. They were within inches of each other's faces. I took hold of Gray and guided him back away from the others, stepping in between him and PC Ings with my legs between them to stop him. I was now able to carry out a brief search and he was helped into the rear of the police vehicle where we transported him to Patchway custody unit. The whole way there he was abusive towards me and police in general. At custody, his detention was authorised under reference 52 SH 107-515. At 1910 hours, I charged Gray with Section 5 public order and cautioned him, to which he replied, and this was recorded directly onto the custody record. Gray had informed us that he had recorded the alleged offence on his digital recording device. I seized this as evidence of the offence and exhibit it as 3851 SJUI when his property was given back to him. So he's fully accepted there that all he's done is, well, he hasn't fully accepted it. All he's done is say that I had recorded the offence. So he's finally he mentions it in his witness statement, but not in the MG5 summary of incidents where the recording obviously was the key issue. There's a separate box that actually deals with the recording to emphasise how relevant recording is, because so much trials are wasted by, in particular, police fabricating anything that comes into their heads, but obviously civilians as well. And the recording clears up exactly what is said, and that is another reason why you don't want Underwood investigating himself, because he then he doesn't say that he looks at the footage. So the fact that I've recorded it, again, is in of itself evidence that he's falsely imprisoned me, because even if there was some basis to an allegation, he's got some obligation to see what he can investigate there and then without necessity of arresting. Whether he's got reasonable grounds of arrest, well, of course, in this case, he knows he doesn't, because what's on the footage is what happened in front of him, need I say. The Section 32 pace is almost certainly a pace search is almost certainly unlawful, because a search has to involve the police officer can only search somebody if there's evidence or reasonable grounds to believe that they are a serious risk of harm to themselves or others, or danger to themselves or others. Of course, arresting somebody for a non-imprisonable Section 5, even if true, does not amount to obviously evidence that somebody is a danger to themselves or serious risk of harm to themselves or others under Section 32. So the search is not only illegal and further assault, but potentially further sexual assault, given there's clearly a sexual element to the whole of Mr. Underwood's restraint and hands-on approach to restraint. He says that Underwood that he uses when it comes to the straddling my thigh allegation. He says that I was lunging at Inge and I was getting too close to Inge. Well, of course, he's already restrained me. He says that he'd taken hold of me. He's put handcuffs on me. He's a massive male. He's obese. He's very overweight and also very large anyway, big boned, as they say. And he on his own has managed to arrest me and take me outside to a car. So the officer is free, and Josh Ings was a very large officer in his own right. So you would have thought, firstly, that he would get involved in the restraint of me if I'd lunged at him, and secondly, Inge is clearly getting into my space, because I'm literally being physically restrained by Underwood at the time. So even that version of events is utter fabrication. I was never charged or never suspected of assaulting a police officer or attempting, which even if I'd attempted to lunge at him and assault him, headbutt him, that would have counted as an assault, and I'm not even charged with resisting arrest. So the grounds of having to restrain me at all. But then what possible justification would it be to straddle somebody and then have your clearly, if you're going to straddle a large male, somebody who's large in their own right, as I am, you're two large men, one of whom is straddling the other's thigh. The idea that you're not going to have contact with the thigh, with the groin region, is absolutely ridiculous. And Underwood keeps it there, and he didn't deny this in subsequent civil trial. he keeps it there for a couple of minutes, and Underwood was forced to address the issue of the sexual assault allegation in a what's called a form. Form 419, which is when a police officer gives a sort of a statement, effectively a witness statement, although it's not a witness statement, it's called something else for some apparent bizarre reason. But when he was investigated by Professional Standards Department by PS 3712 Giles Baisley, or Basley, however that's pronounced, after the incident, after I made the complaint of sexual assault, Underwood made the following statement in relation to that. Response to allegation of sexual assault by the police vehicle. Well, not sexual assault by the police vehicle, which is the literal translation of that, but he means next to, or when it's not by, he was pushing me against the vehicle, so I was backwards, my arms trussed behind my back, while this large, not very pleasant looking male police officer straddles my leg for a good couple of minutes. And he says, quite simply, no, I was not responsible for a sexual assault. In the process of sorting the transportation of Mr. Gray to custody post-arrest, I felt the need to step between him and a colleague of mine. Due to Mr. Gray's behaviour, this meant my legs were straddling his. As far as I'm aware, there was no contact, and in no way did I intend there to be contact of any nature. Well, this is ridiculous. I mean, contact. If he's not clear, but he seems to be suggesting there's no contact of any part of his body as he's straddling me. And when he claims that I'm trying to lunge in, or there's some kind of physical movement from myself, struggle of some description. The idea that unless even if Underwood would literally have to be made of matchsticks or levitating for him not to have physically made contact with my thigh in any situation, let alone for that lasted for a couple of minutes. And of course, Giles Baisley is so corrupt, he doesn't even bother to ensure that in the statement is indication of how long Underwood was in this position, because obviously if it's just a momentary thing which happened in the process of an ongoing struggle, that would be one thing. But when he's doing it over, when I can't move because I've got him he's pushed me against a vehicle. I've got no freedom with my arms. My arms indeed caused pain, and my shoulders are, because of the angle he's pushing my body back against. Bearing in mind, there's no allegation that I've assaulted anybody or I've committed any form of violence at all. I'm shouting, which people do all the time in all kinds of ways. It doesn't justify extra force or violence from Underwood. I'm trying to get attention to the issue because nobody else is interested. Nobody's recording any police brutality or potential police brutality, even if there wasn't any in front of the library staff at the time. And somebody being loud is not an excuse to bend them up, as the expression goes. And in any event, again, this is more patent perjury and lies, because if Underwood's straddling one of my legs, he doesn't even clarify that he's actually straddling one of my thighs. He just gets between us, between me and Ings, or whatever, however that's pronounced. So just utter fabrication and cover up with and non-investigation from just the sexual assault allegation in its own right, whether or not I was being lawfully detained and kidnapped in the first place, which is of course now a matter for the criminal courts, because I'm now being charged, and the CPS have now said there's a case to answer, and we'll come on to the issue of the sound recording of the video and what interest the CPS took in this matter. So during subsequent civil proceedings before, in due course, Judge Ralton, so in that case, when the matter was dealt with civilly, I was given disclosure of documents that were passed between the CPS and the police. And one of the documents, I got two correspondences. One's from a V. Kudlach. I don't know if I'm pronouncing that correctly, but it's spelt on the screen there. It's come up on the screen, and you can see who V. Kudlach is, because there's no further information about him or her, and there's certainly no trace of him or her on the internet. But obviously, to some extent, they're a solicitor or a paralegal who works within the CPS. In terms of the conduct of this prosecution against me, you'll note that even my surname isn't spelt correctly, and then we'll carry on with the rest of the information. The chances of the defence, this is to Underwood. So Underwood's still carrying on the investigation, even though the alleged in the MG5, there's no allegation of my counter allegation of the sexual assault allegation, or indeed my version of events at all, except the arguably incriminating statement about what I'd actually said, as though that's relevant to anything given it was recording. But that's the only reference to what the circumstances were. Of course, an absolute whitewash of the 5th of February incident, which was gone into great detail during the recording of my interaction with Dumble and O'Neill. The chances of the defendant pleading guilty are remote. So once he has entered his plea on Thursday, when preparing the upgrade file, please take Section 9s from Sandra Evans, the independent, in quotation marks, witness, and a couple of the library staff who are willing to come to court, i.e. Elizabeth Stockdale and Anna Green, possibly. I do not think we need everyone to make Section 9s, but a reasonable sample will be helpful, as Dee will no doubt make accusations against our officers, so non-police witnesses are essential. I have asked WCU to warn above witnesses, but if they are unable or unwilling to assist and statements are obtained from other witnesses, please let WCU know to warn them immediately. Was Dee's, that's D is obviously Mr. Gray, the defendant's mobile seized and analysed? If so, did he capture his own abusive behaviour? If yes, can this be copied and exhibited, please? So there's all sorts of things wrong with that statement. Quite clearly, Kudach works for the CPS, but he talks about our officers. He talks in the first paragraph about our officers, but the CPS aren't. They're not part of the police force. They're supposed to be independent. There's obviously, in every single incident involving police, during arrest or to do with the case, the investigation itself, there will be counter allegations that the investigation is corrupt, that the police use brutal force, that they forced confessions, all kinds of alleged criminality against police, and police are I wouldn't say the prisons are full of officers who have been found to have acted corruptly during an investigation, but there's quite a few of them. Therefore, the CPS are absolutely obliged to be independent about examining the conduct of an investigation or integrity of an investigation by police, not refer to them as our officers as though they're all part of the same team. They're effectively a militia, and this is what I can prove throughout all my videos on newsworthy publications. This is what the police, the relationship between the police, the CPS and the judiciary is simply a closed ranks militia. It's all about looking after themselves and covering their own backs. So we come on to other parts of the statement that prove that. Well, if Kujlax has looked at their obligation, their only real point of reference is the MG5 statement. The MG5 is the summary that even has an individual specific box about the video, about any video recorded equipment or evidence. So Underwood has given his position on that. He claims that there's only post-arrest footage, which would be relevant anyway, given I did in fact shout and swear at officers, which I was entitled to do, given I was being kidnapped and had been assaulted and so on and so forth. So what's going on there? Why would Kudlach not know that there was no evidence according to Underwood? So he's either doubting Underwood's word, everything there just proves the extent to which Kudlach is simply, they're going to prosecute me no matter what the footage shows or what footage exists, or whether Underwood has even lied both about the allegation and against the existence of footage at all of the incident. There's a further document. I should have stated that the communication is the 24th of February 2012 from Kudlach, and there's a later one. So this one is dated the 25th of June. We're now several months on. It's now midsummer when I was arrested in late winter, and so the case is I've had to wait months and months and months, having pled not guilty for this matter, and it's important to bear in mind this is a Section 5 non-imprisonable charge. The worst that can happen is that I would be prosecuted well, the worst that can happen if I was convicted was obviously the ordeal I've had to go through reliving being sexually assaulted and kidnapped and perjured against by Underwood and gang. But the worst that would happen would be a fine. I'm on benefit, so the fine would usually be between £50 and £100. So they're going to spend and potentially a bit of surcharge as well for the proceedings. So the CPS, and we're on to now. We're dealing now with a CPS lawyer, solicitor, who's come up in other proceedings against me by the name of Christopher Holland. And again, there's not a trace of him online except the fact that he's a registered solicitor and he's a senior solicitor within the CPS. Senior solicitor, this is what he calls himself in the communication. Senior Crown Prosecutor, no less. And we'll see what he says about where we are in terms of the footage and the witnesses and so forth. In this communication, as I say, 24th of June 15, I have reviewed the file again. The library staff does not want to give evidence at court. The case will proceed on police evidence only. The witnesses required are PCO 8676 O'Neill, PCO SO 6933 Dumble, PC 1414 Parsons, and PS 3851 Underwood. The library witnesses Elizabeth Stockdale and Anna Green are now unused material and should be dewarned. Please ask PCSO O'Neill to rebook his rest day on the 10th of September 2015. The 9999 call, I apologise for this, in brackets, has been lost at the CPS. Can we have 3 copies of the same? The unused material has been revisited, and can we have additional items to the MG6C and the custody record and note made by Anna Green, copies of same through the link. The custody suite CCTV has been disclosed as unused material. So there's no reference to the footage that was asked for months ago, indeed just 2 weeks after the incident by Kudlach. And Underwood says, well, we're just going to go, I mean, he says it in his statement, not Underwood, sorry, Holland, states in his statement they're just going to go on the police statements. So again, the footage taken by me on my private camera, my MP3 player, not a mention of that, even though some inquiries were made months ago from Underwood, and presumably the fiction is still being maintained by Underwood that the footage is what he says on the MG5, which namely is that it only shows post arrest, which we all know is complete fabrication. So Underwood's with Holland fully prepared to proceed to trial on what is the most petty matter anyway, swearing in a library or being a bit bolshy in a library, for which for which tens of that, if all the police are going to turn up, that you have to pay for them being off duty, you have to pay for the proceedings. So you're talking for a potentially 3 or 4 or 5 day trial, well in the region of many thousands of pounds of taxpayers' money, of which, of course, somebody and you have to. Unfortunately, I don't know the name of the barrister. I've forgotten the name, and I can't find it anywhere in the records. But whoever the barrister was, they were privately hired, so that would have increased the costs of the proceedings even higher. So we come to the issue of the statement that is referred to by Mr. Christopher Holland in the brief note we've looked at, where he's decided that Ms. Stockdale is not going to be called as a witness, or she's refusing to give evidence. We don't know which, but we'll read out a statement and see whether that had any influence in why she didn't actually attend the trial. This was made on the 17th of March 15. I am the above-named person, and I am presently employed as a library assistant at Bristol Central Library, Deanery Road, a position I have held for the past 12 years, predominantly. My duties are customer-facing, and I can be tasked to work at any customer service desk situated throughout the library. I deal with members of the public in relation to book and computer inquiries, pointing them to the appropriate areas within the library. At about 4:40 p.m. on Tuesday, the 10th of February 2015, I was at work on the help desk, which is situated in a central position on the ground floor, when I heard raised voices coming from the foyer near to the entrance of the library, although I could not see anybody at the stage. I could tell it was a male voice and very animated. I then saw a male, around 6 foot tall, chubby face. He was in his mid-40s and he was wearing glasses. He was with 2 police community support officers, PCSO. I knew straight away that this male was called Ben Gray, as I had heard a lot about him from other members of the staff, albeit I had not dealt with him before. I had seen the same male a couple of days earlier in the cafe, which is situated behind the help desk, when he had had a verbal altercation with a member of the public who had brushed against him when he stood up. He was very abusive and aggressive towards him, albeit I cannot remember what was said. He was escorted off the premises by a porter. As a result of this and his behaviour towards staff, I was aware of him. He then approached the help desk and started ranting and raving at the PCSOs, who were about 10 feet in front of the help desk. A member of the public told him to be quiet as he was causing a disturbance, and the library is a quiet place for studying and reading. He then became even more irate. At this point I felt alarmed and distressed, as he was very aggressive, and due to his height he has a domineering stature which I found quite intimidating, having never dealt with him face to face and not knowing what he was going to do. I was thankful that the PCSOs were there. By now 2 police officers arrived, and he continued to rant and rave, whereupon they arrested him, and he calmed down and they led him away. I then made notes of what Ben Gray had said and wrote the following down on a piece of paper whilst it was fresh in my mind. I now produced this as Exhibit 281 ES01. You girls are there. Where is your manager? I want to see Robert Harrison. I know my rights. You can't touch me unless you arrest me. Don't come anywhere near me. You fascist, you Nazi uniform. You can't touch me. I'm going to come here every day and make a scene, kick off until the ban is lifted. A female member of the public told him he was making a disturbance and a noise in the library and he should leave. And he called her an ugly old bag. Well, I didn't call her an ugly old, I didn't call her old bag or bitch. I didn't F, even in her evidence or statement, there's no suggestion that I called her an effing something or other or anything along those lines. Refers to the incident a few days before. This was actually the 5th. She's referring to that involved the male with the sports bag with the German accent. Absolute fabrication. Clearly, if I had assaulted him in any way and the police had turned up, they would have arrested me. If they're going to arrest me for the incident on the 10th, they were certainly going to arrest me if I had assaulted or in any way done anything not being the victim, as could clearly be seen from the CCTV if it was ever examined on the 5th. So she's a witness to that incident, and obviously I could have questioned her about that and got to more of that incident, because that incident is absolutely front and center of all my later interactions with the police, and the incident that then leads to my being arrested, the fabrication from Underwood's, and then the malicious, evil prosecution carried out by Holland and others at the CPS without any interest in what the footage actually shows. And of course, eating into hundreds and thousands, eating into thousands of pounds of taxpayers' money simply by making these gratuitous witness, having to send police out. A whole day of police time would have been taken in getting a statement from her and a similar statement from Green, which I'm not going to bother to read out, but says almost identical stuff, although she didn't see me. She claims not to have been involved in the incident of the 5th, or at least doesn't mention any involvement in that. And of course, none of this would have been necessary if the footage had been examined at the outset, even before I was arrested, or certainly later on my arrest by an independent officer other than Underwood, who had every motive to continue with this lunatic prosecution based entirely on criminal perverting justice, perjury and misconduct in public office, and kidnap from Underwood, in which the CPS are now conniving, and then they now want to involve the judiciary to put the finishing touches to this wickedness, knowing that I can't litigate. So even if or when they lose the case, as the footage will obviously make it inevitable, even the judiciary can't lie about what's on the actual footage in such clear and glare terms. They do. They fully lie all the time about what's on footage in other statements. Although the main process is just to whitewash what is on the footage and then just go with allegations mainly from police officers with the biggest axe to grind you could possibly imagine. So what I'll do is I'll read you some more of the statements from the other officers involved, and of course, it's interesting to note that Miss Stockdale changes her testimony dramatically by she initially gives an account of my interaction with the female, where she doesn't mention any words. I can barely hear myself when I'm responding to her. I'm certainly not shouting at her. I'm saying in a very calm and measured voice what I think of her, and I don't F and blind, and I don't call her a bitch or a bag. So it's clear that last statement that sounds a little bit like I called her a. Although it doesn't use the F word, I called her a bag, an old bag or something. So it goes along the line of I've gratuitously caused her harassment, alarm or distress. So it just goes a little bit, it gives some kind of evidence that I've committed a Section 5 public order with those words, old bag. And it's quite clear that has been tacked on, that an officer who's taken the original statement, they've probably egged her on into giving something incriminating, and then so for no apparent reason she revisits the same allegation to do with the female approaching me and puts on this and inserts this, I'll call her an old bag, which sounds a little bit like old bitch, and may therefore justify some kind of prosecution, albeit she's never finally gives evidence in court anyway. So for completeness sake, we'll deal with Kevin Parsons' sworn witness statement that he made 2 days after the incident on the 12th of February 15, and he states the following. I am PC 1414 Kevin Parsons of the Avon Somerset Constabulary, currently based at the Bridewell Police Station, Bristol. At approximately 16:45 hours on Tuesday, 10th of February 2015, I was on duty in full uniform on solo mail patrol. At this time, I attended the Bristol Central Library, Deanery Road, Bristol, in response to a police radio communication that a mail had arrived at the library and was causing a disturbance. The communication was made by PCSO 6993 Dumble. From his communications, I could hear over the radio that the mail in question had arrived outside the library and had then proceeded inside. I could hear a male's voice shouting as PCSO Dumble made his communications. I arrived shortly before PCS 3851 Underwood arrived. We both made our way into the library together. As we did, we passed a member of the public coming out of the library who said to me, "You have a very angry man in there." Once inside the entrance door, I could hear very loud shouting. Only one person was shouting, and it was a male's voice. From what I observed, the library consisted of one long rectangular room containing books and reading material, and once we had made our way along this section, there was a small flight of stairs around 3 steps leading down to another rectangular section, this time containing several banks of desks with computers on them. It was very busy, and all of the computer stations that I could see had members of the public sat at them. As I approached the flight of steps, I could see 2 PSOs stood facing away from the computer desk at the top of the steps, and one male stood in front of the PCSOs. He was stood around 6 feet away from them. I now know this male to be Benjamin Gray, 1706-1966. I would describe Gray as a white male around 6'1" to 6'2" in height, of large, broad build, wearing glasses with short dark hair. Gray had one arm outstretched to his side. I believed it was his right arm. In his right hand he appeared to have a mobile phone and was holding this out towards PCSOs. I believe that he was videoing them both. He was shouting at the top of his voice and was red in the face, clearly angry. PS Underwood approached Gray from the right side and asked him to calm down. Gray continued to shout loudly and ignored his request. A female, who I thought at the time was a member of library staff but learned later that she was a member of the public, approached Gray and stood between the 2 PSOs. She calmly asked Gray to leave. She said to him, "You are distressing everyone in here. If you want to shout, go outside." At that point, I looked behind her and to the banks of computer stations. I saw the people sat at the stations looking across at the incident, shocked expressions. Gray took exception at being spoken to by the female. I believe he replied something about her get out of his face. He ended his sentence by shouting at her, "You fucking ugly bitch," quotation marks. The female turned to walk away. As Gray shouted this at her, he leant forwards, and given his level of anger, I was concerned that he might attempt to go after her. P.S. Underwood attempted to take hold of Gray's right arm, but he pulled away and said, "Don't touch me. You can't touch me unless you are arresting me." P.S. Underwood then took hold of Gray's arm again and said, "You are under arrest under Section 5 Public Order Act." I took hold of Gray's left arm and we handcuffed him in a back-to-back position. Gray began shouting and swearing and we walked him out of the library. Once outside, P.S. Underwood cautioned Gray, to which I could not detect a direct response through his continual swearing. He was asked to calm down several times and was told that young children were present by P.S. Underwood. I then saw several young children in school uniform walk past, clearly able to see what was going on, and in earshot of Gray. Gray has a very loud voice, and he was shouting at the top of it. The area was very busy at that time, and there were other members of the public walking past us too. Because my attention was focused primarily on Gray due to his aggression, I could not see if these people were looking at us or not. Suffice to say, they would have been able to clearly hear what he was shouting. He was shouting abuse at us and also generally swearing. I do recall he several times used the words fucking pigs. He was continually swearing. At one point, Gray's behaviour worsened to the point that he had been restrained against the police car. So he's actually giving more information than Underwood gave about the restraint that he used when he said by the car, but actually at least Parsons has admitted, and of course he's another officer that's present. So there's Underwood, Inge, and Parsons. Parsons himself is fairly large to have restrained me if I was in any way going at Inge or a threat to Inge, as Ings, how it's pronounced, as Underwood claimed. And yet there's at least 3 burly officers on hand that wouldn't have to involve, therefore, Underwood's genitalia in part of the restraint process, certainly for several minutes. At one point, Gray's behaviour worsened to the point that he had been restrained against the police car. As this happened, he began to shout that PS Underwood had sexually assaulted him. Gray was placed into the rear of the police car, and PS Underwood and I transported him to Patchway Police Station with myself as the driver. As soon as I began driving off, Gray began insulting PS Underwood. He was shouting again at the top of his voice at times and saying, "You big fat fucking pig, you're a fucking porky face cliche, you fat pig, you can't even breathe properly, you fat useless pig, you're a slug, see you in court, you little ape, I will Sinn Fein the fucking court." I don't know what that, I didn't say that. Of course, you remember at the beginning of my first altercation with whatever his name is, Community Support Officer Dumble, he refuses to wear a camera. None of the officers are wearing cameras. They're supposed to, I'm fairly sure, even at this stage, even though it's not more enforced nowadays. But the lack of cameras, so that the officers can say whatever they like. They know that my MP3 player / camera has been turned off. Once at Patchway Police Station, Gray's detention was authorised. During the booking in procedure, Gray requested that I conducted the search of his person instead of PS Underwood. I searched his upper body with no improper items. I began the search of his lower body. I began by placing an open hand on the top of his outer thigh and one at the top of his inner thigh, the purpose being to detect whether he was concealing any items in the legs of his jeans. Immediately, Gray began shouting that I had sexually assaulted him. He shouted so loud that I saw members of the custody staff turn from their computers to look at him. His face was red and contorted. I stopped the search. Gray then turned to me and said, "Just fucking get on with it." The search continued and was completed, finding no improper items. Gray was shortly released from the custody centre, and I had no further dealings with him. So there we go with Kevin Parsons' interpretation of events, some of which is actually true. I did complain about him sexually assaulting me. Of course, I am being sexually assaulted continually. If I'm being continually groped by officers and my detention is not lawful. And of course, the key incriminating evidence that I've shouted at the female per se and even went to go after her aggressively was all fabrication. We can hear from the sound recording that I'm very measured and my voice is low and very controlled when I speak to the female in response, albeit she's communicating with me and approaching me in an extremely aggressive and terrifying situation in which I'm the victim involving the police. But yet I'm still calm and measured with her. I don't shout at her, and I certainly do not call her an effing ugly bitch, as Parsons did. And this statement was made 2 days after my initial arrest, with Underwood as the lead investigator. He's clearly, you can't have a coincidence where 2 officers fabricate or mishear such a clear-cut allegation. We have Stockdale, the civilian independent witness, although not independent at all, but because she's a member of the staff with whom there was a dispute about what happened on the 5th. But she claims to have misheard that I called her an ugly bag, but she doesn't hear any F word. And of course, they're accusing me of shouting. So there can't be any mishearing if I'm shouting, and I've got a loud voice, as Parsons is keen to point out. So it's not, you can't mishear somebody when they're shouting, and if they're effing and blinding, calling people bitches and effing this and that, you're not going to mishear it if you're standing right next to them, as Underwood and Parsons were doing. Notwithstanding, officers are supposed to be more observant than the average civilian. For completeness, we'll look at PCSO's Nathan Dumble's witness statement that he made bizarrely on the 1st of June 2015. So again, we're getting close to trial date now. It's not indicated when, as I say, the footage was finally looked at, but the investigation carries on. The statements now, because now, of course, Chris Holland has directed that he wants the police to that only the police evidence is going to be relied on, and apparently not even the film footage. And indeed, as I recall, it wasn't actually relied on by the CPS, although they then played it for the trial itself. But anyway, as I say, more time, more public money to continue with this perjury and what is obviously a persecution against myself, not just against myself, but against the public justice system. Mr. Christopher Holland, who's clearly the boss man in this, is the senior lawyer, the trained solicitor, and a key member of the CPS, a senior member of the CPS. And so he's now just conducting what is patently a personal vendetta between myself and various of the CPS, including Holland, who's been involved in other failed prosecutions against me, and they're just getting their own back, punishing me for in any way raising my head above the parapet and trying to address in the only way I could in all my circumstances the attack on the 5th of February, and no concern because I'm in the firing lines, as you will see time and time and time again in newsworthy publication documentaries. There's no concern for the innocent civilians on any basis, not just in terms of obviously abusing the justice system per se and conducting perverting justice, which is to drive a stake through the heart of the legal system, as judges will always point out when they convict people and sentence people for perverting public justice allegations or perjury. And they're using perjury and perverting justice to not only drive a heart through the system, but of course, this German male, not only could matters, of course, if I had properly resisted Underwood, as I should have done, I'm welcoming them. At the end, I'd rather just be arrested and have this matter dealt with, and then I can put it before a criminal court, than obviously have any sort of ongoing issue with Dumble and Underwood and gang. Anyway, so the arrest is probably the only way forward for this matter, but that is for the sole intention of getting all the issues investigated, including what happened on the 5th of February, and then it all comes to light through the proceedings. But of course it doesn't, because you get the CPS who just completely whitewash even the evidence of the criminal misconduct that happened on the day, let alone on the 5th of February. So Dumble states as follows: I am PCSO 6993 Nathan Dumble of Avon Somerset Constabulary, based at the Bridewell station with full traffic warden powers. On the 10th of February 2015 at 16:40, I was on joint patrol with PCSO 8676 O'Neill in a marked police vehicle. I parked the vehicle outside the Central Library on College Green, Bristol, due to information that a male known as Benjamin Gray, 11766, was going to attend and cause a disturbance. The information I received from communications was Gray had been banned due to aggression towards the staff. I waited a short time inside the police vehicle in company with PCSO O'Neill when I recognised the male walking towards the Central Library entrance to be Gray. I have spoken to Gray previously in the city centre and also seen Gray's image before, so I was able to identify him. PCSO O'Neill and I got out of the police vehicle and walked slowly towards Gray. Gray stopped, looked in my direction. At this point, I was approximately 10-15 feet away from Gray. Gray said, "Are you here for me then?" Straight away, I could see Gray was agitated by the tone of his voice, and he was stepping from side to side and looked on edge. So I'm a wild-eyed, drug-addicted caricature, which you can hear from my voice. I'm completely calm, despite being confronted and intimidated by uniforms, despite having been repeatedly falsely imprisoned by police. I try and engage with him in a straightforward legal matter. What rights do you have to prevent me, to warn me, to get involved with the ban? Civil matter itself, and you can hear just Dumble just winding me up the whole time. Oh, this is the way it is. It's just because it's the way it is, attitude continually. As Gray got closer to me, within 5 to 10 feet, I could see that he had some kind of device, looked like he was being used to film the incident. Gray then said, "You will need to get the real police to stop me entering the library." Well, just a quick pause there. Of course, as I mentioned, both Dumble and O'Neill mentioned the fact that I'm filming, and of course Kevin Parsons mentions it as well. So if Christopher Holland from the CPS had, as he said, looked at the file, he would see that several officers had said I was filming from the outset. So how could that square with Underwood's fabrication that the film only showed post arrest? Well, the footage only showed post arrest. Gray then said, "You will need to get the real police to stop me entering the library." Gray was very aggressive in his manner, and I felt that the potential was there for Gray to possibly become physical towards PCSO O'Neill and me. Well, the physical is that anything's possible, isn't it? It's irrelevant, and there's nothing about my conduct, as you can see from Dumble's interaction with me, that would give them pause for concern that I'm about to attack them. But that's just more fabrication from and just caricatured lies from Dumble. Gray stated, shouting similar words to "You're Nazi, fascist, bully boys in uniform, you're not even police." Gray was very vocal, shouting. He went red and scrunching up his face in anger. Gray then entered the library, PCSO O'Neill and I followed Gray inside through the main doors into the main library area close to the information desk where staff was present. I then contacted communications and asked for other officers to come to my location and assist as Gray had entered the library and was acting in an aggressive manner. PCSO O'Neill and I were stood facing Gray and explained that he was not welcome in the library. I think it's supposed to say, but it says either library, and that the best course of action would be for him to leave and not cause any issues. A short time after, I think it just means to say 3 to 4 officers, but a short time after, 3 to 4 officers arrived in the Central Library to assist with Gray, asking to leave the premises. Gray again became aggressive and shouted, "None of you have an O-level between you, you fucking apes." Gray was very aggressive to the police officers who attended, flaying his arms around and shouting. Gray was then arrested by PS Underwood. Gray resisted and was physically trying to push the officer away. PS Underwood. So we've got different versions even about the arrest. That I was stopped there. I think said I'd calmed down after arrest. I was resisting arrest, although I wasn't charged with that. And even Underwood doesn't make that allegation. Underwood, the arresting officer. PS Underwood received assistance from the other officers who attended the location. Gray shouted at PS Underwood, "You are a big fat fucking pork pig." Gray continued to shout and swear when taken outside to the police vehicle. This was a busy time of day and numerous members of the public were outside, including school children at this time. Throughout the whole incident, Gray was very aggressive, confrontational, anti-police. Gray caused a breach of the peace due to his aggression and inappropriate language. Within the library, a member of the public approached Gray and asked him to go outside and stop shouting, in which Gray replied with, "Bitch." The staff and security who were present seemed genuinely intimidated by Gray and were all aware of him and the issues that he has previously caused within the library. I did recognise Gray and have spoken to the male previously within the city centre of Bristol. From the start to the end of the incident, which was approximately 20 to 30 minutes, I had a clear view and the male did not leave my sight until he was placed within the marked police vehicle and transported to custody. So there you have. I mean, Dumble's order of events is just completely scrambled. I've been arrested and taken outside by the time he refers to my interaction with the female. So it's not clear when I've actually engaged with the female or if that has anything to do with my arrest or occurred after I've already been arrested. Within the library, a member of the public approached Gray and asked him to go outside and stop shouting, in which Gray replied, "Bitch," but there's no evidence of, I didn't say bitch. And earlier he states, Gray again became aggressive and shouted, "None of you have an O-level between you, you fucking apes." Well, so he's taken an F word from the main central thrust of Underwood and Parsons, who have both said that I'd called the female an effing ugly bitch, and he's removed that and actually said I called Underwood a fucking ape, or said it in front of him or towards officers prior to my being arrested. Which itself, of course, would be a public order section 5 offence if I'd shouted such abuse, because even if it's at officers, because even though officers themselves are supposed to have thicker skins according to I think it's Otton or one of the recent rulings. It certainly doesn't apply to other members of the library, and therefore I would be causing harassment, alarm, or distress to the other library users. So there you have the litany of complete and utter fabrications to support Underwood's original fabrication in the MG5. Underwood's decided that I haven't told the female to F off, but that I have launched a torrent abuse of the female, and in fact, which is the original complaint, but in fact called her a effing ugly bitch, which is provably of full, complete fabrication from the footage. Officers refer to my filming from the outset, and the CPS either knew that the footage proved that I never said the words, or were genuinely misled by Underwood's statement to say that the footage only showed post-arrest. But of course, that would still have to have been examined. So the CPS, of course, are supposed to independently examine the evidence. So bearing in mind the onus on that, they can't be independently assessing the case, because the police bring endless bad prosecutions, as we know. And so it's inevitable that at some point, it's ridiculous to suggest that officers would have described me filming the initial incident, and they didn't look at the footage, because even if you go from Underwood's version, I'm effing and blinding and sort of potentially committing an offence even after arrest, of course, although if I'm being illegally detained and manacled and abused and kidnapped, then of course how I react to that is, even including using force, even if I had resisted, as alleged by one officer, which was in any event fabrication, it's obviously different from any abuse or verbal abuse or swearing that's occurred before I've been arrested, especially if that was the justification for arrest. So it's inevitable that Holland knows full well that this is fabrication. Indeed, the extent that we know that he knows, that the CPS know that the film footage proves every single statement, and even after they're getting more statements from Stockdale and Green from the civilians, and getting further statements from the police well into June, they knew that the footage already proved everything they were saying was complete fabrication, complete perjury, complete perverting justice. We can see that because they continued with the prosecution. They played the footage not just once, but for there was a one-day trial at Bath before District Judge Taylor, and unfortunately I don't want to give the incorrect district, because I think there's more than one District Judge Taylor. I think the Judge Taylor that dealt with my case has retired, and I don't want to give the wrong name, so I'm not entirely sure what District Judge Taylor it was, but in October in Bath, I think it was the date of trial. We'll come to the trial in due course. That's the final part. The footage was in any event relied on, and it was played so that I could question, obviously having to represent myself in the criminal proceedings, throughout a whole day. When Dumble came on, Underwood came on, Parsons came on. They all give different, contradict themselves in terms of their own versions, but every version was contradicted. But whatever version it was that involved calling the female an effing ugly bitch, torrents of abuse, shouting, threatening members of the library users, other library users, etc., was all proven as utter fabrication by the footage, and so Taylor just sat there passively and allowed himself and his courtroom, and a British courtroom, to be just a forum for officers just to perjure themselves as to any degree they liked. I'm surprised they didn't accuse me of murder and arson whilst they were on a roll. You know what I mean? Hi viewers, welcome to part 2 of Judge Alexander Ralton, the Demon Butcher of Bristol. This second part is called simply the civil trial, and this deals with matters that unfolded before Judge Ralton, or indeed even before they reached Judge Ralton, by way of pre-action civil proceedings, as it's called. That's correspondence between myself and the Chief Constable of the Avon and Somerset Constabulary's legal team. In this case was represented by Sue Dauncey, MBE, and Sue Dauncey, as we shall see, denied any wrongdoing on the part of Underwood or any of the officers of the Chief Constable. And even though they knew that I would litigate as a consequence of them refusing to agree liability or settle on any basis. What should have been a slam dunk set of proceedings, it's important to point out with the actions against the police that the more usual course, as anybody who goes online and researches this will be able to verify, that the police will agree to settle even when there's potentially they're not liable, or there's no possibility even of them being found liable, because obviously the costs of them defending the case has to be set up, because it's set against the potential costs of losing it, and even if they win it, of the still incurring huge amounts of cost that would make it in their interest to try and settle, and that could even include refusing to accept liability, so simply settling out of court but without any admission of wrongdoing, which is one potential avenue that should be explored, not least because it's the public money that's being banded around in these situations. But of course, in my case, I've got a slam dunk case where the last thing Sue Dauncey or the Chief Constable or PS Underwood would want is for these matters to be trawled into open court and examined with potential members of the press taking an interest. But of course, again, in my case, the judiciary have the local press in their pockets. I'll be able to show more evidence of that in other documentaries, but the Bristol Post, chiefly involving Jeff Bennett, who's the chief senior court reporter for dealing with civil and criminal trials of those kind of issues, they will be the first port of call for the national press to become interested in due course. But Jeff Bennett and all the cronies at Bristol Post have suppressed all the outcomes of all the proceedings involving myself for the last 15 years. The last time they got involved was to falsely publish that I had assaulted 2 security guards on the 1st of June 2010, long before I was even charged with assaulting the security guards, and that matter was discontinued, was dismissed as no case to answer in the criminal courts on the basis, as the magistrate ruled, that I had been the victim of being illegally restrained by the security guards and therefore being assaulted by them, not the perpetrator of assault, and that the police evidence had lacked credibility. So when that finding against the police was emerged and became the finding of the courts to dismiss the original allegation of assaulting security guards, the Bristol Post weren't interested. They were happy to publish the story before I'd been convicted, stating as fact that I had assaulted 2 security guards, clearly on information provided to them by the police involved in the incident itself, and that's what we're dealing here with the Bristol Post. So of course, everyone from top to bottom involved in the incident of the 10th of February 2015. Know the fix is in, and that they can get away with this, and therefore they will challenge it, and they will, if necessary, have it all the dirty laundry done in open court in due course, knowing of course that they'll have the judiciary in their pockets just as the Bristol Post are in their pockets, and indeed effectively the Bristol Post are in the pockets of the judiciary, because it is obviously the judiciary who are spearheading and have the power to enable the persecution of myself via public resources and the access to the public justice system by way of their position as judges. And of course, as we shall see later on in this documentary, Judge Ralton It was from Albion Chambers originally. He was a barrister at Albion Chambers who got elevated to becoming a judge in Bristol. Albion Chambers is the number one chambers in Bristol, pretty much. They're right opposite the Bristol Crown Court, and the dozens of or many barristers simply hop over the road and become judges in the Bristol Crown Court, where they've been working for 20 or 30 years anyway. And whenever I'm for vast periods of my life, I've been continually prosecuted by the CPS, run by from a barrister who's still at Albion Chambers, and then the judge, jury, and executioner, also from Albion Chambers, dealing with my serious allegations of CPS corruption, represented by a mate from his old chambers. This happened with Judge Martin Picton, Judge William Hart, Judge I think Judge Mark Horton, but I may be wrong about him, Judge Michael Longman, Judge Miles Watkins. Miles Watkins, I think, is his name, but the list is endless of ex-Albion Chambers barristers and judges who, with whom I've had dealings, personal dealings. David Chidgey is another, who now sits part-time as a recorder. And as I say, the list is extensive, and obviously, the more I'm accusing Albion Chambers of being involved in a conspiracy, the more that the evidence bears out this is exactly what's going on, the harder it is for me to avoid going before an Albion Chambers crony, Albion Chambers old boy. But we'll come to that, because obviously there's more to it, as we shall see. But before we deal with the criminality just within the listing process, deal with obviously the main point, which is the criminality within the events of the 5th and the 10th of February 2015. So pre-action protocol, as I say, is when you set out what your claim will be, and you give the other side a chance to respond, and then depending on what the response is, whether they accept liability or deny it, or what their grounds are, is whether or not legal action can go ahead. And it's important to bear in mind, I keep mentioning money, but this case was to cost, I think, in excess of £25,000 simply for the legal fees, but that doesn't include obviously the use of the court, the days of trial, the extra security that was put on, because they do this especially for me, because I'm always treated as the sort of as the violent offender. That is the policy in terms of the staff within the various courts that I have to attend, and this was at the Bristol Magistrates Court, and there's a whole issue surrounding that, as we shall see. But I'll read out the claim form, so that this is a very brief version. There's the particulars of claim which would attach with the claim form, which is slightly more convoluted and more detailed. But at the same time, I'll just cut to the chase and read out the one paragraph that summarised what my case against Underwood was, and therefore against the Chief Constable, who is vicariously responsible for the actions of her junior officers, such as Underwood. At approximately 3:24 p.m, 10:02:15, I called police stating I had been banned from the Bristol Library and there may be a public order incident, as I intended to defy the ban and address the scurrilous calumnies which justified it. On arrival outside BCL, Bristol City Library, I was approached by PCSO 6993 Dumble and told I should not enter the library and should in fact leave the area, despite not being accused of committing any offence. Dumble and several other officers continued to intimidate and harass me in an effort to get me to leave as I entered the main area of the library. At one point, I was approached by a female who began to blame me for the altercation. In response, I asked, do I want an ugly thing like you coming in my face? At which point, PS 3851 Underwood ran at me and started to manhandle me. I protested that Underwood could not touch me unless arresting, which Underwood disputed before informing me I was under arrest for a Section 5 POA Public Order Act offence. At one point during arrest, Underwood straddled my thigh. I could feel his genitalia against me. I was taken to custody, charged for the Section 5 POA offence on sworn evidence from Underwood et al. I had called the female a fucking ugly bitch, quotation marks. Video footage with sound proves I used no such language justifying arrest charge. The basis of charge arrest was fabrication and perjury, and ergo the defendant is liable for false imprisonment, assault and malicious prosecution, including trial. I seek aggravated, and the trial referring to the criminal trial at Bath before District Judge David Taylor, as I found out his name was. I seek aggravated and exemplary damages due inter alia to the corrupt nature of the above, including sexual assault. So nothing could be more straightforward. I don't even go into detail as I did in particular as a claim about the incident on the 5th of February and the collusion with police over that, which of course I should have concentrated more on, because that was perjury and perverting justice in its own right, certainly perverting justice, by not seizing the CCTV, even when Elizabeth Stockdale gave evidence supporting to some extent my the allegation that I'd been approached by the man with the large sports bag. And of course, who in their right mind, who isn't the biggest and most evilest corrupt liar on earth, could possibly argue against the allegation? The clear facts was that the grounds of arrest were fabricated, that I'd never sworn at the female, I'd never called her a bitch, and I certainly had not opened up a torrent of abuse against her or threatened her or any of the library staff, as stated by Underwood. And there was cold hard evidence that had been supported in the criminal court, and bear in mind there is this legal expression, it's called res judicata, which means it's already decided. So there's no dispute that the footage proved that I had never said the words. That was why the judge had ruled there was no case, i.e. that it should never have been brought in the first place. That is the clear meaning of a no case to answer. It means that the defendant is not required to give evidence or knock down the evidence provided by the CPS because their evidence is found as false, although. So, as I say, Miss Dauncey, who's a member of the British Empire, no less, and clearly an experienced solicitor by any standards, denied any liability. At this point, I was actually legally represented. I had a Mark Andrew Leese, who's from Beasley and Company solicitors, who agreed that I did have a valid claim against the police for false imprisonment and assault, and wrote the pre-action letter setting out the issues that have been raised in this documentary surrounding evidence of the fabricated allegation that I called the female a fucking ugly bitch and that I had been assaulted and sexually assaulted by Underwood. Notwithstanding I was represented, so that you expect a more valid response, therefore, from the other party, in this case Sue Dauncey, member of MBE, and I'll read out her response to Mr. Leese in respect to the allegations he had set out on my behalf. Claim for unlawful arrest, false detention, assault, sexual assault, malicious prosecution, and perverting the course of justice following your arrest on the 10th 2015. We write further to your letter of claim dated the 15th of October 2015. We have completed our investigation and liability is denied. We rely on the following facts. 1. You telephoned 101 at 15:20 p.m. on the 10th of 2015. During the conversation with the call handler, you asked to repeat some information. You raised your voice, and when the call handler asked you not to shout, you responded, I'm on the way to the library. I've tried to sort it out with you, but it's quite clear you're not prepared to be reasonable. I'm going to the library now. I'm off to the library. Goodbye. You terminated the call. You telephoned 999 at 16:17 p.m. on 10/2/2015. You told the call handler you were going to Bristol Central Library in about 10 minutes. You advised the call handler of an incident that happened on the 5th of February 2015 and explained the library had issued a ban based on this incident. You told the call handler that you were on your way to the library now and you wanted the police there. You tell the handler that you are going to create merry hell, that you're going to have the police there, and if you have to, you will shout the place down. PCSO 6993 Dumble is asked to attend the Bristol Central Library, is told that you have telephoned the police, that you have said that you are going to library because you have received a letter saying that you had been banned from all libraries in Bristol and that you would create merry hell and shout the house down if you needed to. PCSO Dumble is informed that there had been a previous disturbance at the library. So here we see already Dauncey is completely whitewashing the complaint that I've been assaulted with a guy with a bag who had barged into me nearly knocking me off my chair, giving me a shock, and then laughing when I ask him to apologise and address him about the assault, and saying he's going to chop me up into little pieces for the amusement of a library full of people and only a stone's throw from where the children's part of the library is. None of that is mentioned. It's the key factor in all of what ensues on the 10th of February, and it's completely whitewashed by this liar, Sue Dauncey. So we go on. PCSO Dumble and PCSO O'Neill attended the Bristol Library and spoke to the library security. Fishponds Library had already advised the Central Library of your intention to attend, and extra security had been arranged by the library. I didn't find out about any of this. This is complete news to me. You arrive at the Bristol Central Library and approach PCSO Dumble and PCSO O'Neill. You film your entire interaction with them and are confrontational throughout. The PCOs ask you not to go into the library because you are banned and advise you to leave the area. They repeat this advice on a few occasions. You ignore their advice and enter the library. PCSO Dumble requests another unit to attend. PCSO Dumble confirms that you will not listen to their advice and are being quite aggressive. You can be heard shouting in the background of this communication. PCSO Dumble tells the police communications unit you are going to the library and is concerned that you may kick off. Police Communications Unit asked PS 3851 Underwood to attend the library. PS Underwood is told that you had been involved in an incident 5 days earlier and that you are now banned from the library. He is told that you are now at the library and he is to attend on a Code 1 response. PS Underwood entered the library and saw you raising your voice and with your arms in the air gesticulating aggressively in front of two PCSOs. PS Underwood approached you and asked you to calm down, but you continued to shout in an aggressive tone. The library was extremely busy with members of the public, either reading or using the computers. These members of the public were turned and looking towards the disturbance you were causing. They appeared shocked by your behaviour. PS Underwood believed that you were causing other members of public distress. A female member of the public approached you, explains that people are trying to work and asks you to take your argument outside. P.S. Underwood believed the fact that the female approached you and asked you to leave meant that she was clearly distressed by your behaviour. Words are exchanged between you, and the female and P.S. Underwood and P.C. Parsons both believe they heard you say the words fucking ugly bitch towards the female. P.S. Underwood decides to arrest you for a Section 5 public order offence. He takes hold of your arm to usher you away from the female in order to arrest you. You continue to shout, and at the first opportunity, P.S. Underwood informs you of your arrest. You are arrested at 16:50 p.m. and you are handcuffed in the rear stack position. As you are taken outside, you continue to swear and shout abuse at the officers. There are members of the public outside, including school children. Well, you notice the clever words, you continue to swear and shout. So she's asserting that after arrest, I was simply continuing with the swearing and shouting, which I was committing prior to my arrest. Although I do not, I shout, potentially raise my voice at the officers, but I'm not shouting at any members of the library users per se, and I'm certainly not swearing at any stage prior to my arrest. So that's already a fabrication, because whatever she's claiming that Underwood and Parsons believe, and they both separately believe they heard me hear specific incriminating words that weren't said, is obviously for the birds anyway, but she could obviously make some sort of vague suggestion, distance from the criminality by saying that it's what they believe rather than what she believes. Or that she believed what they believe, which is obviously absurd if what they believe is ridiculous. So they could believe that the moon is cheese, but that wouldn't be a credible reason. That's not any more reasonable than saying that they believed I said words I clearly didn't say. But in this case, she's actually cleverly making the allegation that I was swearing, and of course, as we shall see from Underwood's witness statement, he continued to maintain I was swearing in the civil proceedings, in a separate sworn statement of the civil proceedings. Indeed, he seemed to increase the amount of times he's accusing me of swearing now to more than one, whereas it was only one, even when he changed the original allegation to telling the female to fuck off and then saying that she was a fucking ugly bitch. And then it was continuous abuse, which Dauncey is accusing me of, even when Underwood himself hadn't given that evidence except that he said a torrent of abuse, but that didn't actually include specifically swear words. You are asked to calm down, but you continue to shout and swear. Prior to placing you in the vehicle, PS Underwood conducted a Section 32 search. As he is conducting the search, he felt you lunge towards PC Ings. PS Underwood repositioned himself to stop you getting to PC Ings. You accuse PS Underwood of sticking his groin into you. You are placed in the police vehicle and transported to Patchway custody. You arrive at custody at 17:40 p.m. The custody record was opened by PS 224 Wiltshire at 17:58 p.m. Whilst PS Underwood explained the circumstances of the offence, you advised that you believed you told the female that you didn't want her fucking ugly face coming into my face. Detention was authorised at 18:06 p.m. to secure or preserve evidence and to charge. During the booking in process, you alleged that PS Underwood had sexually assaulted you and asked if PC Parsons could conduct the search. Whilst PC Parsons conducted the search of your person, you accused him of sexual assault. When PC Parsons stopped the search as a result of your accusation, you told him to just get on with it. Once the booking in procedure was complete, you were processed. You were charged at 19:14 p.m. with a Section 5 public order offence and released on conditional bail to attend Bristol Magistrates Court at 9:15 a.m. on the 6th of March 2015. The condition was not to go to Bristol Central Library. So those are not the facts by any long margin. The facts aren't that I continued to shout abuse after I was arrested or swear and shout abuse, because the footage clearly proved, and the footage is what contains the facts, not Miss Dauncey stating whatever she wants to say that comes into her head. So she's already lying about that. It's quite preposterous that she genuinely believes that these two officers both separately believed very specific words were called by called by me against the anonymous female. When the recording proves that nothing I say comes remotely near such abusive words, and they can't both have coincidentally thought exactly the same kind of fabricated statement. So she's already colluding. Like, she makes no mention of the MG5, so she's completely missed out that Underwood either lied about having viewed the footage when he hadn't viewed the footage at all, and certainly lied about the content of the footage, whether or not he viewed it, because he said it only showed half the post arrest, which obviously was irrelevant to the arrest for the Section 5 and the fucking ugly bitch allegation, which the video that Underwood conveniently didn't look at proved that I never said, and that he had fabricated that allegation. So she hasn't dealt with the facts at all. She hasn't dealt with the finding of the criminal court. She hasn't even mentioned the fact that I was acquitted of the charge for no case to answer. That the judge said there was nothing to bring the case for in the first place. There was no evidence. The video proved that I never committed the Section 5 public order allegation as set out, and my grounds of arrest were complete fabrication. And it's all completely whitewashed, and so she hasn't dealt with the facts at all. She's lied where she can. Offence having been committed. Section 24 states that if a constable has reasonable grounds for suspecting that an offence has been committed, he may arrest without a warrant anyone whom he has reasonable grounds for suspecting of being guilty of it. P.S. Underwood had reasonable grounds to believe that you had committed a Section 5 offence, as he witnessed your disorderly behaviour within the hearing and sight of members of the public who are within the library and who he believed would cause distress by your abusive words and disorderly behaviour. He heard you shouting and using swear words towards PCSOs and the female member of the public, and he saw you gesticulating aggressively by flailing your arms. He saw that members of the public were watching you and appeared distressed. He believed that the fact that one member of the public approached and asked you to leave meant that your words and behaviour were causing her distress. He believed you heard her say the words "fucking ugly bitch" towards a member of the public. So what Miss Dauncey is saying is what an officer claims to believe. Let's just leave to one side whether he actually believes it or not. But what he claims to believe is reasonable suspicion. But it doesn't matter how untrue that belief is. Obviously, what is a reasonable belief is if I had said words very similar to "fucking ugly bitch," I can't think of what they would be, but so there would be some reasonable suspicion because there's perhaps some understanding of why he was mistaken in hearing the words that were said. But when I specifically don't see anything even approximately, bearing in mind he's saying that I'm shouting at her, to the extent that, indeed he said that I was so aggressive that he had to restrain me. But when the sound recording shows that I'm completely passive, that my voice is neutral and not raised, and I'm clearly spoken, as many people have pointed out, certainly in courtrooms, and clearly if I'd used the word fucking ugly bitch, the officer would have heard them. And if I haven't, if they're not picked up on the recording, it's because I haven't said them, and the officer's fabricating them. And clearly, fabricating evidence is not reasonable. If he had reasonable grounds of suspicion, he would have arrested me and not had to fabricate fucking ugly bitch allegation to create reasonable suspicion. Notwithstanding his original claim, which is of course ignored by Dauncey also, is that although she says generally that I was swearing at the female, Underwood initially claimed that I told her to fuck off. But the essence of the fabricated allegation is clearly on the swearing, and Dauncey not only just simply colludes in the fabrication, but creates her own fabrication by saying that you continue to swear after arrest, thus stating that I was swearing prior to arrest. So that is her response to the reasonable grounds claim. She is certain she can go into a British courtroom and in the civil proceedings under oath convince a civil court judge that Underwood had reasonable grounds of suspicion to arrest me for calling a female a fucking ugly bitch, even when the footage shows and the criminal court has ruled the footage demonstrates I never said those allegations. What does Miss Dauncey say about the footage? Not one single word. Not one single word is mentioned about the recording of the images of the incident. She's supposed to be addressing the facts. That's the title of her outline of the facts in the beginning of her letter, and she's doing nothing of the sort. If she was interested in the facts, she would go solely on what the recording showed, not on what the officers said. And even if she was going to then weigh up what the officer said against the recording would obviously take priority. But it can't be not mentioned at all. That's not dealing with the facts at all. That's dealing with the fiction that I swore at Underwood. And of course, the irony is that the swearing is supposed to cause Section 5 public order, but I've had to listen to Underwood swearing in front of me. I've been deprived of my liberty. So this officer has sworn the very thing that he says causes people upset and distress and justified his arrest, when I was not the one who ever swore in public at all, but he's swearing at me only in the context in order to justify having kidnapped me on the complete fabrication and sexually assaulted me as part of the process, on the complete fabricated allegation that I have effed and blinded in a public library. And of course, even if I had, the force to detain me has to be proportionate. How is it possibly proportionate to put me in rear stack handcuffs, leave indentations on my wrists, and straddle me against a vehicle, or push me up? One of the officers, I think it's Parsons, as I read out in the witness statements, stated that I have been pushed against a vehicle, all without any suggestion that I'm committing that I've assaulted an officer or attempting to assault an officer or resisting arrest. So with no suggestion of actual physical resistance from me, or certainly no formal allegation of that. Miss Dauncey deals with none of it, and so in order to challenge it, she knows that she's going to have to stump out on the taxpayer, because it's the taxpayer, of course, who are paying council tax, who then goes to the wages of the police, and a cut of their wages then goes to the legal team. Then Miss Dauncey deals with the sexual assault allegation. After you were handcuffed, PS Underwood attempted to conduct a Section 32 search of your person to ensure you did not have anything on you that would harm you or any of the officers. Whilst PS Underwood was conducting the search, he felt you lunge towards PS Ings. PS Underwood stood between you and PC Ings to control you and stop you making contact with PC Ings. PS Underwood accepts that his stance was trying to control you may have appeared as if he was straddling your leg, but he denies any accidental or deliberate contact between his groin and you. So in terms of the straddling of the leg, it was not made clear from Underwood whether or not he specifically, in terms of all his previous responses to that criminal allegation, in the investigation by Baisley, in Miss Dauncey's response, in his sworn witness statement in the civil proceedings, in his sworn witness statement in the police prosecution case, he never clarifies whether he actually straddled my leg, and if so, for how long. He seems to admit that to Baisley, but it's still vague, and Miss Dauncey doesn't investigate it, as that's the whole point of her responding to that claim. And how could it appear as if he was straddling my leg? If it's my leg, I know whether he's straddling or not, and it's Underwood's groin and his legs who knows whether they are straddling mine. And either he straddled my leg and he did, or he didn't. Assuming that he seems to accept in the previous statements, he does accept it in the trial. But it's on transcript, and obviously the judge didn't order any transcripts and then lied about the evidence that Underwood gave. But obviously the very fact that it's not properly investigated, that there's no determination about whether he straddled my leg and for how long, and then there's no evidence given by Ings to support the allegation that I struggled towards him. There's no explanation as to why Ings, who's a big guy, couldn't control me, didn't involve himself in defending himself. I'm not accused of trying to assault an officer. I think Parsons or one of the other officers is certainly present. So there's 3 officers standing right next to me. I was not accused of any. So it's all complete manure being produced by Miss Dauncey. And once she's lied about the effing, prior to arrest, the swear words from myself, then nothing else is of any relevance. In due course, a lawyer called Robert Talalay was hired by the Avon Somerset Police, or the lawyer, to continue with the denial all the way into court proceedings, and he furnished us with a sworn witness statement, which is only partially dated. It says this day blank, day of November 2019. There's a Rory Davis's signature, or his name anyway, and it's presumably his signature, and he's a solicitor for the legal department of the Avon Somerset Constabulary. But Robert Talalay's name is attached to the statement in capitals above Rory Davis's statement. So I don't know how much validity the statement has beyond the fact it actually went before court and was considered by Judge Alexander Julius Ralton, who obviously will come to in due course. But Robert Talalay states the following. The defendant is the Chief Constable of Avon and Somerset Constabulary. Any police officers and police community support officers herein referred to were, at all material times, acting under the direction and control of the defendant in the lawful performance of their police functions. So we can see straight off the bat, in theory, I don't have to read the rest of the statement because, of course, lawful functions do not include simply fabricating that somebody has called somebody a fucking ugly bitch when film recording proves that they have done no such thing. But anyway, paragraph 2. On the 10th of February 2015, the claimant attended Bristol Central Library, the library in quotation marks, despite having received a letter notifying him that he had been banned for 6 months. Police attended and sought unsuccessfully to persuade the claimant not to enter the library. When inside the library, the claimant proceeded to shout abuse at police officers and then a female member of the public who intervened. The claimant was then arrested on suspicion of having committed an offence under Section 5 of the Public Order Act 1986. The claimant was transported to Patchway Custody Unit, where he was detained and then charged that evening. The claimant was prosecuted by the Crown Prosecution Service and was ultimately acquitted at trial on the 30th of September 2015. The claimant claims damages, including aggravated and exemplary damages from the defendant for false imprisonment, assault and malicious prosecution. No part of that claim is admitted. Headline, factual background. On the 5th of February 2015, the claimant attended the library regarding a disturbance involving the claimant. Officers who attended determined that no crime had been committed by the claimant and he was released. It was noted on the log that the library would seek a banning order. On the 10th of February 2015, the claimant was arrested on suspicion of committing an offence under Section 5 of the Public Order Act 1986. It is averred that all use of force and the arrest of the claimant were lawful in every particular. Particulars of lawful use of force and lawful arrest. 1. At about 15:20, the claimant phoned the police and, referring to the incident on the 5th of February 2015, appeared agitated and aggressive on the call, culminating in him saying that he was going to the library. At about 16:17, the claimant again phoned the police stating that he was going to the library after receiving a letter stating he had been banned from all libraries in Bristol. The claimant stated that he was going to create merry hell, in quotation, and shout the house down, in quotation. PCSOs Dumble and O'Neill were dispatched to attend the library and were warned that the claimant was banned but was going to attend so as to cause a disturbance. PCSOs Dumble and O'Neill arrived at the library at or about 16:40. After a short amount of time, the claimant arrived at the library. The PCSOs made efforts to convince the claimant not to enter the library. The claimant's words and demeanour towards the PCOs were insulting and aggressive. At about 3.5 minutes, the claimant entered the library and went towards the information desk, followed by PCSOs. PCSO Dumble spoke to communications seeking additional officers due to the claimant's aggressive manner. At or about 16:45, PC Parsons and PS Underwood entered the library. When inside the library, the claimant ranted, shouted, and acted aggressively towards the defendant's officers and library staff, all in the presence of the general public, including children. The claimant was repeatedly asked by the defendant's officers to calm down and to stop shouting. The claimant shouted that the only way the matter could be resolved was through the criminal courts. A female member of the public approached the claimant and requested that he leave as he was distressing the people in the library. The claimant proceeded to shout at the female, who asked him to leave, culminating in aggressively and rudely referring to her appearance. PS Underwood honestly and reasonably believed that the claimant has called the female, in quotations, a fucking ugly bitch. At about 16:50, PS Underwood arrested the claimant for an offence under Section 5 of the Public Order Act 1986. PS Underwood placed his hands on the claimant to pull him away from the female as A. he was concerned for the safety of the female, and B. so as to effect the arrest. PS Underwood honestly and reasonably believed that the arrest was necessary to obtain the claimant's identity and to prevent him committing further offences. The claimant was told as soon as was practicable of the fact of and the reason for his arrest. The claimant continued to shout abuse and swear at the defendant's officers. Due to his words, demeanour and attempts to pull away from the officers holding him, PS Underwood applied handcuffs and an appropriate level of tightness in a rear stack position. The claimant was escorted outside. In due course, PS Underwood conducted a search of the claimant pursuant to Section 32 of Police and Criminal Evidence Act 1984. The claimant was then transported to Patchway Custody Unit. Following the claimant's arrest on 10th of February 2015, he was detained by the defendant's officers. It is averred that the detention of the claimant was lawful in every particular. Headline: Particulars of lawful detention and lawful use of force. As set above, the claimant's arrest at or about 16:50 on the 10th of February 2015. The claimant was transported to Patchway Unit, arrived at about 17:40 on the 10th of February 2015, with the custody record opened at 17:58. The claimant's detention was authorised by 1806 by PS Wiltshire. During the booking-in process, the first claimant stated that he did not tell the female member of the public to fuck off, but that she was fucking ugly or something, and I think I said I didn't want a fucking ugly face coming into my face. At 1914, PS Wiltshire authorised that the claimant be charged with breach of Section 5 of the Public Order Act 1986. The claimant was released on conditional police bail at 1917. The claimant was detained in the defendant's custody for 2 hours and 27 minutes. At or about 1945, the defendant's officers seized the MP4 device on which the claimant had videoed the events at the library. The claimant was prosecuted by the Crown Prosecution CPS service. The video footage taken by the claimant was provided to the CPS on or about the 29th of April 2015. Following a contested trial, the claimant was acquitted at Bath Magistrates Court on the 30th of September 2015. Response to the particulars of claim. Headline: except insofar as each and every particular set out in the particulars of claims is consistent with the above, it is denied. Except insofar as the contrary is explicitly stated, all paragraph numbers referred to hereafter are those in the particulars of claim. Except insofar as they expressly accord with the contents of paragraphs 4 to 7 of this defence, which are repeated, paragraphs 1 to 13 are denied. For the avoidance of doubt and without prejudice to the generality of this paragraph, it is specifically denied that 1. PCSO Dumble or any of the defendant's officers harassed or intimidated the claimant as alleged or at all. 2. PS Underwood pressed his genitalia into the claimant's thigh, whether by intention or accident as alleged or at all. And 3. Any of the defendant's officers perjured themselves as alleged or at all. 11. Next paragraph. Paragraphs 14 to 16 are noted and the defendant does not plead evidence. Paragraph 5 of this defence is repeated. As to paragraphs 17 to 19, which are denied, the defendant repeats paragraph 5 of this defence and avers that the use of force by PS Underwood was at all material times lawful, so as to effect the claimant's arrest pursuant to Section 117 of the Police and Criminal Evidence Act 1984 and or Section 3 of the Criminal Law Act 1967, and or so as to protect another person from harm, and or as agents of Bristol City Council to remove the claimant from the library from which he had been banned. And that's more or less it. The key issues there are denied. He doesn't go into any of the details as to provide an alternative to what happened in terms of whether or not he doesn't even expressly state whether or not he accepts that I called the lady a fucking ugly bitch. He says that he claims, or he swears under oath, as sworn out in the statement, that PS Underwood honestly believed that he had heard me call the female a fucking ugly bitch. Or indeed, as he stated in his sworn statement, shouted at those words at the female in question. And so the only two real issues that need to be decided are whether whether I was kidnapped and whether that allegation was perjury or whether it wasn't. And Talalay denies perjury having taken place, but provides no alternative explanation as to why there is no sound recording of my calling the female the words in question, the words that form the basis of the charge and the arrest. And of course, he is supposed to be independently assessing the whole case as a judge and court should be considering it, not simply excluding anything that's inconvenient to his client that doesn't address the actual substance of the claim which obviously transfers over into serious criminal allegations, as I've already expressed, in terms of perverting justice and perjury, because the two things are completely interchangeable in terms of the grounds of the claim. And he doesn't look at the footage. There's no mention of the footage. This is repeated over and over again. If you look at my video of my most recent video, Barbarians at the Gate, it deals with the fact that at no stage does the trial judge deal with footage of the incident or what the footage shows and set out clearly what the footage shows in all the way through the trial proceedings, all the way through the investigation, and then when it's the appeal is refused by Lord Justice Adrian Fulford. Again, he calls me a liar and everything under the sun, but doesn't accepts. It makes it quite clear he doesn't look at the footage either and independently assess what's in it. And obviously Talalay is not only doing the same thing, but it means the judge is going to have to, at some point, going to address the fabrications set out in the video evidence, and that's going to have to be at trial. So Talalay earns a huge bundle more money defending the matter at trial. He could try and offer to settle the matter even without admitting liability, because he knows I'm very poor and would appreciate any kind of settlement, or would certainly consider any settlement without even having to admit liability. Because and Judge Ralton, before we even come on to the substance of the allegations about Judge Ralton in relation to the actual issue surrounding my arrest on the 10th of February 15, there's all manner of corruption in terms of the venue, and of course Judge Ralton's involved. Judge Ralton, I need hardly add, if you go and look at my mission statement or look at other videos, is from Albion Chambers, the most prominent chambers, or one of the most successful high-profile chambers in the Bristol area, or indeed across the West Country and all the way to Wales. They have a big office right opposite the Bristol Crown Court, and most of the judges who are sitting Bristol Crown Court are from Albion Chambers, as used to work at Albion Chambers as barristers. And of course, they still interact with the chambers, given it's just over the road, and it's all they're effectively part of one happy club. And of course, Ralton was part of these issues. And of course, the issues that I was going to be bringing into play is that I am being victim of being persecuted by, in particular, Albion Chambers barristers and judges, because they're the ones who I have most dealings with in previous proceedings. Judge Martin Picton, Judge Longman, Judge Hart, Judge Ford. The list is endless of judges who I've been in front of, all from Albion Chambers, all with allegations of similar kind of nature, where I'm accusing the police and the CPS of colluding in the most heinous criminality of assaults and kidnappings and perjury and perverting justice, as I am making out in terms of the 10th of February 15 arrest. And of course, what happens, but when both parties are known to each other, me and barristers and judges from Albion Chambers, who gets listed? A barrister from Albion Chambers, or former barrister from Albion Chambers, Judge Alexander Julius Ralton, and therefore should have recused himself, even if he was accidentally listed, which he clearly wasn't. He was listed specifically because of his conflict of interest, because it would be breaching my Article 6 right to a fair and 6.1 Article human right to a fair and independent tribunal, which in this case was Judge Ralton. He should have recused himself there and then. And that isn't even the half of it, because even before he was appointed, who is dealing with me at the time, who's dealing with my case per se, it's the designated civil judge for Bristol Court. And that designated civil judge is a judge called Judge Barry Cotter. Now, Judge Barry Cotter is an interesting judge because he was actually stationed in Exeter when he was brought over from Exeter to deal with several claims, or mainly, I don't know if he had other matters, but at the time he was dealing in sort of about 2013, 2014 period, where I had a load of claims that were before the civil court. They were 3YK 14936, and then I'll just do the endings. It's 14990, and then 3YL66586, and then M15992, M5150, and those cases each represented an occasion where I've been falsely imprisoned, injured by the police frequently. On one occasion, CS sprayed on the 1st of June 2010, CS sprayed by the police. And so I had a whole bundle of cases that had cost the taxpayer already about £90,000 in having Mr. Talalay and other, I'm not sure exactly which barristers they were at the time, because it was alternated between a Robert Talalay and a man called Mark Leigh Morgan, who's from Sergeant Inn's Chambers. But in any event, the compiling of those defence statements and preparing for each case dealt with as a separate trial had cost the taxpayer over £90,000, and that's of course to exclude all the cost of trial of hearings and proceedings as well. And in those matters were in theory supposed to go through before a jury as well, but I withdrew proceedings. I withdrew from my initial trial with before Judge Cotter, because he was just bellowing at me. The police were being allowed to perjure themselves hand over fist. It was simply torture to have to be degraded in the way that I was being degraded by Judge Cotter, and those proceedings will be obviously subject to other documentaries. But of course, he's now made himself very popular with the local judiciary, and he's been promoted from the circuit judge, as he was being, to a designated civil judge, which is a senior member of the judiciary for the civil courts. And so he gets an extra, obviously, a bump in his salary, and he's on the way up to becoming what he is now, which is a Mr. Justice Barry Cotter. So I would suggest, obviously, just in the same way, if you go to my video of Barbarians at the Gate and you look at my video of how Robin Sellers was a recorder, and once he was appointed to deal with Mr. Gray and cover up and collude in all kinds of evil police misconduct, criminal misconduct, and hush hush to do with the the case concerning Barry Cotter and Ralton and all the rest of it. As his reward, he was made to circuit judge. He didn't have to go through the boring business of becoming a silk, so he went straight to almost to the top of the pyramid in terms of the hierarchy of senior judges in the country. So anyway, we deal with Judge Cotter because Judge Cotter in 2014 made this damning judgment against me. I walked out of court and said I'll deal with the matter through the criminal courts effectively, and I said I was going to consider citizens arresting Mark Lane Morgan because he was a perjuring colluder in all the allegations I was setting out. And Judge Cotter, in the case reference that I've just read out, sort of made the following comment, which he had taken from Mrs. Justice Swift in proceedings in 2012, and of course that would be a matter for another documentary down the line. But in this very brief hearing before Judge Swift, she made the comment, effectively like a curse, but I'll read it out and then you can judge for yourself. She stated, this is at paragraph 9 of Judge Cotter's judgment, referring to a previous comment from Judge Swift. The claimant, that is Ben Gray, is a man who has an obsessive and paranoid belief that every public body and every public servant, brackets, including any judge who has had anything to do with one of his claims, close brackets, is dishonest, corrupt, and intent on persecuting him and preventing him from obtaining justice. That belief does not extend only to public bodies and their employees, but also to private individuals, in particular his neighbours. One outlet for his preoccupation is litigation. It is clear, and has been confirmed by his behaviour today in court and by his submissions, that he will continue persistently to litigate in the administrative court in the future if he is not restrained from doing so. It is a gross waste of public resources for the courts and indeed defendants to have to deal with repeated claims made by the claimant which are totally without merit. Well, Judge Cotter was quoting from Mrs. Justice Swift, having actually found that I had been falsely imprisoned by the police in the claim that I walked out of, and ordered them to pay £1 costs, or directed the jury that they had it in their power, having slagged me off in the way that you can clearly see there. And having made that comment in respect to the that trial and me walking out of that trial, he refused to withdraw from the other 4 trials that were listed before Bristol civil courts to be contested, before a jury, and said he was going to keep hold of the case. So I refused to attend and get involved to degrade myself and the justice system by continuing with a clearly biased judge, even after he made that comment. Which was clearly the most prejudiced, violent, personal attack it would be possible to draft without actually using expletives, which he almost comes to, because he's certainly offensively accusing me of being some paranoid, deluded maker of false allegations. Entirely without merit claims do not include a claim that has enough merit to go to a jury, which accuses officers of kidnapping and perverting justice and assaulting and injuring, often with substantial injuries, as a consequence of being false imprisoned. Even at the very highest, any evidence, unless somebody is convicted, it is automatically the onus by law is on the police to prove that the arrest was justified. That is the starting point before we deal with missing CCTV footage and all the same stuff that we see laid out in terms of the conduct of Sean Underwood and Robert Talalay and so forth. So this judge was the designated civil judge who appointed Judge Ralton, because having made this comment about me being paranoid, and that every altercation I have, even in where the neighbours themselves have criminal convictions and themselves often are in trouble with the police, I'm told that whatever it is, it's always Ben Gray's fault. Whatever the issue is, just refer. And this is so the comment of Judge Swift, which is then quoted by Judge Warby to then justify entirely preventing any form of civil litigation. Judge Warby, who's an old boy from Bristol, used to go to Bristol Grammar College, and was clearly listed as the biggest crony to the latest crony from 2017 to 2019, making more orders on the request of the police, who had already been found at the time that Judge Warby was making the orders to have falsely imprisoned me on repeated occasions. So the very person, the chief constable, who's responsible for all my false imprisonments and assaults, was asking for them to continue to treat me in this way and not be accountable before the civil courts, and to have orders put in place from the highest court to prevent me being able to react legally at all to any form of misconduct from the police, based on this same quote that Judge Warby himself cites in case reference CO2B5071, that is the Chief Constable of Avon Somerset Police versus Ben Gray. So this quote has now become a fatwa, which is just simply trotted out, not only by judges, but by the police themselves, so that whenever I make an allegation of sexual assault or kidnap or perjury or perverting justice, all they do is just say, look at Judge Warby's and Lady Justice Swift's, well, she's not Lady Justice, but Mrs. Justice Swift's comment and Judge Cotter's comment. It's all Mr. Gray's fault. He's a paranoid lunatic, and nothing he says has any substance at all, except on the occasional admitting by the police or finding by the courts that Mr. Gray's been kidnapped or falsely imprisoned and assaulted by the police, except when he wins case after case in the criminal courts, even without representation. Mr. Gray's a nutter, effectively, is what Mrs. Justice Swift. And of course, even if I was what she says I was, she doesn't refer to any evidence that I provided about the contents of my own head, in where I've expressed any view about all judges being in cahoots against me, or having the thoughts that she's saying I have about all judges and all members of the legal establishment and all members of the civil service. The only way she could make such a finding is if I had expressed such a view, and she would have quoted from that. And I've repeatedly said, if you can provide me one quotation where I've actually expressed that view, I will stop litigating, or even threatening to litigate, or even campaigning through what I'm doing now through the social media and through public forums such as YouTube. And of course, they can't provide any such evidence, because I never expressed such views. They are entirely fabricated and entirely relied on, so that the hundreds of thousands of pounds can be wasted. Because of course, the flip side to the preventing me litigating is, as I say, it doesn't hold any water in the criminal courts when they try and prosecute me to shut me up, which is why obviously they bring the most trumped up, just as this case was. They just continue to bring any perjury, to rely on any perjury and any reaction to me to being assaulted or kidnapped or sexually assaulted or whatever, and just concentrate on my reaction to what is glaringly a criminally corrupt persecution led by the judiciary. So with that comment in mind, it was no wonder that I went before Judge Ralton, who was from Albion Chambers, and therefore part of the general counter allegations from me that I'm being the victim of being persecuted, in particular by barristers and former barristers of Albion Chambers. There was another issue, which is the venue itself, because I have been repeatedly injured at Bristol Magistrates Court in Marlborough Street. On the 1st of June 2010, I was CS sprayed in the face, and I'll show you a little bit of the clip of the footage from that as I'm talking. This is the aftermath, when I'm being dragged around by handcuffs, having been CS sprayed in the face, after it was found that I was illegally being restrained by the security staff from leaving a court when I had every right to do that, to leaving a courtroom. And the judge having found that the officer that did the CS spraying into the face, not just CS sprayed me, but the security guards as well, was, that her evidence had no credibility in terms of her justification for using the CS spray, and an allegation that I had struck out at the security guards before being restrained from them, which the security guards who actually restrained me, Mr. Matthew Warner and Gavin Manley, Mr. Matthew Warner and another security guard who I forget, had said that, made it quite clear that they started restraining me because I was trying to walk past them. So despite being the victim of both being illegally restrained and then CS sprayed in the face, and then tortured because I was denied medical treatment after the CS spraying, that itself is obviously another documentary about judicial cover-up in my being tortured and colluded and judicial collusion in the torture and perjury and perverting justice and misconduct in public office surrounding the events of 1st of June. But put that to one side, obviously I'm having to revisit these traumas and having my face rubbed in the horrors of what I suffered on the 1st of June 2010. And also I had a chunk of my wrist effectively removed when handcuffs were yanked by a member of GOAMI, which is the prison dock officer people that security take care of prisoners, because I was when I was under arrest, sort of in detention on the 15th of April 2015, and I've received a permanent scar to my wrist from this injury. That too was never properly investigated. Liability was denied in respect to that. That matter went before Judge Ralton, and Judge Ralton had no problem, because I had hearings at Bristol Magistrates Court, in having the hearing about the incident on the 15th of April 2015 involving the injury that occurred in the Bristol Magistrates Court building itself, and then had the hearing about the civil proceedings against the incident when witnesses from that incident were still in the proceedings, were still present at the working in the very court building, facilitating the hearing about the civil complaint about the injury that was received, the torture that I endured from Stephen Bristow, which of course Judge Ralton dismissed on a pretext, notwithstanding there was glaring evidence of criminal torture and other perjury and perverting justice surrounding that matter that Judge Ralton was colluding in, whether or not he had his decision to strike out the claim in the civil courts was justified in terms of a technicality, in terms of being out of time with an element of the claim involving personal injury. But obviously I'm having to in any event, when I attend the trial in respect to what occurred on with Underwood in February 2015, the proceedings that turned on that, obviously I'm having the sadistic, vicious exploitation of Judge Ralton and Robert Talalay on forcing me to relive the horrors of the 1st of June, being gassed in a court building as an innocently detained person, and being attacked again, with having a chunk of my flesh permanently removed and left with a scar. So I've been branded as though like some medieval slave, quite literally, with the full knowledge and collusion of Judge Ralton. And then he ensures that the trial concerning the conduct of Underwood, or the alleged sexual assault and abuse that I suffered at the hands of Underwood as part of that claim, be decided at a venue where these horrors have occurred, at Bristol Magistrates Court. Judge Ralton, obviously in the hope that either I would just be too terrorised and traumatised to even attend the trial at all, or if I did, that obviously I would be mentally reliving those horrors and not being able to properly focus on the issues in the trial itself. But pursue the matter, or contest the matter, the police certainly did. as I say, we've now reached the stage where the judge, Barry Cotter, who's expressed the personal views about me as a litigant and as a human being, and agreed that I'm an obsessive paranoiac who makes stuff up and who thinks everybody in the social services is against me. So he's effectively become a witness in the case, effectively as a bad character for a character assassination against me. He then appoints Judge Ralton, who has his own conflict of interest because of my complaints about Avon Chambers, and is uninterested and unconcerned with forcing me to relive the injuries, the physical tearing of my flesh, because the CS spray acts, certainly the stuff they used in when I was CS sprayed in 2010, eats away at the skin. It burns whole layers off the skin. So whilst I was detained without access to fresh water, I had and over a couple of days, I had to have whole chunks of my face shaved off because of or removed or fell off from the burning effects, and parts of my body as well. Judge Ralton was happy for me to relive that experience. So returning to the proceedings themselves, Robert Talalay has provided the defence he has, completely whitewashing the key grounds of the claims concerning the perjury, and we move on to the statements from the witnesses that are now going to be given in the trial that I brought in terms of the allegations against Underwood and others. Underwood provided the sworn further witness statement, so he doesn't just rely on the MG11 or Section 9 witness statement he gave for the police for the proceedings when he was the complainant, or the witness, certainly, and the investigating officer. And he provided this further witness statement that was signed the 29th of June 2020. So this is many years after the fact. Of course, he's now listened to the tape, even if whatever stage he ever did actually even once examine the footage or claim to have examined the footage. God knows what actually went on there, but he certainly has had the opportunity to examine it, if only because it was played over and over again during trial proceedings in which he was giving evidence in the one that concluded in September 2015. So Underwood states as follows: I, Police Sergeant 3851 Sean Underwood, currently stationed at the Patchway Police Station, will say as follows. I am a sergeant within Avon Somerset Constabulary, the Constabulary. I joined Avon Somerset Constabulary as a police constable in June 2002. I was promoted to the rank of sergeant in 2015. This witness statement has been provided via email. So I'll just skip over the boring bits. On the 10th of February 2015, I was on duty as a sergeant at Bridewell Police Station in the centre of Bristol. At approximately 16:45 hours, I received a radio call from the Constabulary's communication unit. I was informed of an incident at Bristol Central Library, the library, where a male was being abusive and acting aggressively towards some police community support officers, PCSO, and he was refusing to leave the library. I attended the library with one of my colleagues, PC 1414 Kevin Parsons. PC Parsons and I located two PCSOs, Nathan Dumble and Luke O'Neill, in the main room of the library. The PCSOs were in company with a male, Mr. Benjamin Gray, who I understand to be the claimant in these proceedings. I was not familiar with the claimant prior to my attendance at the library. The claimant was shouting loudly at PCSOs Dumble and O'Neill and continued to shout as I approached. I asked the claimant to calm down, but he continued to shout and informed me that we, which I understood to be the police, could not do anything. In my statement at Exhibit SU1 and my notes at Exhibit SU2, both of which are full and accurate accounts of events on the 10th of February 2015, I state that it was obvious that the claimant's behaviour, where his shouting and general demeanour were threatening, was causing distress to all of the members of the public I could see. At one stage, a female approached the claimant and asked him to leave because he was causing a scene and distressing to the people trying to work. The claimant acted aggressively and told the female that she had nothing to do with it. I heard the claimant call the female a fucking ugly bitch. I have watched and listened to the audio recording of the incident made by the claimant on his phone. I accept that the phrase fucking ugly bitch cannot be heard. I'm able to hear the claimant say, "Do I want an ugly thing like you coming in my face?" I'm unable to say now whether the words fucking ugly bitch were said and not picking up on the footage, or whether I simply So say now whether the words fucking ugly bitch were said and not picked up on the footage, or whether I simply misheard. The claimant was certainly cursing and swearing loudly and consistently throughout the interaction, and after arrest swore at me almost continually on the car journey until we arrived at the custody suite. All I'm able to say is that my notes are an honest and true reflection of what I believe I had heard. He goes on, I then took hold of the claimant's arm to move him away from the female who had approached him. The claimant continued to shout. As the claimant continued to shout, I informed him that he was being arrested for a Section 5 public order offence. As is detailed in my witness statement at Exhibit SU1, I considered the arrest of the claimant was necessary to prevent further offences, which I felt would be committed if the claimant was allowed to remain inside the library, and also in order to ascertain his identity, as at that stage I had no idea who he was or where he lived. The claimant continued to shout at me the entire time, calling me such things as fucking fat pig. The claimant tried to pull his arms away, and therefore I decided that I would place him in handcuffs, both for his safety and my own. I applied the handcuffs to the claimant in the rear stack position, which means the claimant's arms were behind his back. I succeeded in escorting the claimant from the library, and once outside, I cautioned him. The claimant continued to shout loudly once we were outside, screaming vitriol at me and the other officers at the top of his voice. It was a busy time of day, and there were numerous people in the vicinity, including young children who would all have heard the abuse and foul language, and the claimant was directing towards me and the other officers. I searched the claimant in accordance with my powers under Section 32 of the Police and Criminal Evidence Act 1984. While searching the claimant, I felt him lunge forward in the direction of the officers, PC Ings. I took hold of the claimant and placed my legs in between the claimant and PC Ings to prevent the claimant making any contact with my colleague. I can categorically say that I did not press my genitals into the claimant's thigh or do anything similar. I completed my search of the claimant before transporting him to Patchway Custody Unit. The claimant continued to abuse my colleagues and me for the entire journey to Patchway. I briefed the custody sergeant on our arrival, and the claimant's custody was authorised. I subsequently reviewed the evidence available to me, including the log of the call to police, and briefed the custody sergeant, who authorised that the claimant be charged with an offence under Section 5 of the Public Order Act 1986. At approximately 1910 hours, I informed the claimant that he had been charged, and I also cautioned him. The claimant informed me that he had recorded the incident on his digital recording device, and therefore I seized this items as evidence of the offence. In due course, I disclosed the footage to the CPS as part of their review of the evidence. Well, again, just utter fabrication from start to finish, dealing, of course, with the particular issue of whether I called the female fucking ugly bitch. No, rational, reasonable rebuttal could rely on him not having heard or mishearing what was clearly heard on the footage. The footage, if anything, is obviously going to be less clear and less distinct than it would be from real life, having Mr. Underwood standing right in front of me, listening to what I'm saying. So it is a complete fabrication. That's the first bit of evidence. Of course, he doesn't address why he told PS Wilshire that I told the female to F off, because he doesn't even make that allegation in the witness statement himself. We have the fact that other officers who gave evidence, I can't remember which one it was off the top of my head, but at least one other officer made exactly the same quotation, "you fucking ugly bitch," that Underwood had made. And it's impossible even for Underwood to have misheard so specifically that he heard an F word, which wasn't made. And he goes on to say that whatever he may have been mistaken about with the fucking ugly bitch comment, the claimant was certainly cursing and swearing loudly and consistently throughout the interaction. No swear words left my mouth until long after I had been physically restrained by Underwood, which I felt to be kidnap and assault. But prior to that, there was no cursing and swearing. So he's continuing with the fabrication. He's not only continuing with it, he's exaggerating it to involve more allegations of swearing, so effectively effing and blinding. He doesn't specify what he heard, as he did specify with the initial comments to the anonymous female. But it's just he's just all he's done is reinforce the extent to which he's fabricating evidence. This is going before Judge Ralton, whose judgment makes it clear he's heard fully the evidence from the sound recording and visual recording of the incident. And he accepts that he's not suggesting there's anything faulty with the recording, so he's dismissed that of Underwood's preposterous claim, because you would hear there would be some technical clicking or something to indicate that the footage wasn't, was being interfered with, and it's continuous noise from both of us, so there's no sort of periods of silence. And the noise that's coming from me doesn't come anywhere near to shouting at the female. There's no suggestion, no evidence of. He's using this word threatening as though any sort of heated interaction with any person immediately equals threatening bystanders who are watching the altercation. It's abundantly clear that if I was threatening in my demeanour and therefore intimidating members, other library users, the female would not have approached me in the first place to tell me to go somewhere else. She's not only approaching me, she's approaching me not to offer support, but to harass me into leaving as though she knows what the incident about and that it's all my fault. So it blows. Everything that comes out of Underwood's mouth is a provable fabrication from start to finish. And it's one thing for him to, tell this to his mates down the pub when he's had to, when the police forces accepted liability and paid compensation. It's another just to carry on and increase the amount of lies he's told originally, because the amount of F words I use simply increases exponentially every time Underwood comes near the case. It's F off when it's when we're standing in front of Wilshire. Then it's fucking ugly bitch when it's in the Section 9 police statement. And then it's a torrent of abuse and repeatedly, what does he say? It was swearing and cussing consistently throughout the incident. So it's now a torrent of swearing and cussing to heap on top of the increase in the amount of swearing and cussing he's accused me of prior to arrest, and all of which is completely as if there is no recording, but really because he knows that the judge is going to be in front of will be either Judge Ralton or somebody else from Albion Chambers or with strong Albion Chambers connections, with an axe to grind, with a major conflict of interest the size of Ben Nevis. And he's just going to collude in and permit any kind of perjury, almost solely just for the main issue of torturing me. I mean, because now I'm having to relive the torture of having to listen to anybody lying about somebody else is not to be able to do anything about it. But this man, the state is funding these proceedings to the tune of eventually well over 25,000. The 25,000 was simply the costs to Robert Talalay to pay for the big London big shot with his connections, and tens of thousands of pounds on top of the tens of thousands that have already been wasted in persecuting me in the criminal courts by bringing the matter before the criminal courts in the first place, and obviously to put me in debt where I've been ordered to pay costs now of another 25,000, and generally as part of the campaign to terrorise and shut me up. But of course, needless to say, the Judge Ralton dismissed all my allegations and provided his judgment as his reason for doing so. And I'm not going to read out the whole judgment. It's very long-winded and deals mainly with issues that have nothing to do with the grounds of the claim. I'll take you to an example of this, sort of a brief headline, where he actually puts a headline, Gray's relationship with the library, or an example of why I wouldn't want to waste your time reading the entire judgment is because at huge public expense, if you bear in mind how much these proceedings have now cost the taxpayer, bearing in mind the 25,000 just deals with the payment to Talalay, so obviously taking up a judge's time for several days of trial is further expense, and then of course there's forming the transcript at yet further expense, and he believes as part of the remit of examining whether or not Underwood has sexually assaulted me or kidnapped me or falsely imprisoned me under the law, is relevant to that for him to put in his penneth worth about Mr. Gray's relationship with the library. No human being has a relationship unless they suffer from some kind of perversity with an inanimate building. Whether he's talking about the library staff is not made clear, but assuming that's what he is stating. He states, it appears accepted that Bristol City Council is the beneficial owner and operator of the Bristol Central Library. So therefore my relationship isn't with the library, it's with the Bristol City Council. At all relevant times, Mr. Gray was in receipt of benefits. He told me, and I accept, that he wanted to use the library for entirely lawful and socially acceptable purposes. So under the headline, Mr. Gray's relationship with the library is him dealing with whether or not I was assaulted by this German male and the police were colluding in that assault and threats to chop me up into pieces. He states, it is common ground there was a further incident in the library on the 5th of February 2015. Mr. Gray told me that a German man banged into him and refused to apologise. I have no idea why Mr. Gray referred to his nationality. It seems that Mr. Gray challenged him and the man threatened to cut him up into little pieces. By now it's irrelevant what's actually happened between myself and this male. I've only identified him as having a German accent because I didn't know his name. If I was told his name, I would have referred to him by his name. But it's usual for somebody to pick up on a particular distinct characteristic to identify them from just an anonymous, even more anonymous person. And it was something that I happened to notice about him. But the issue was that the police had refused to investigate it. I can clearly be heard on the sound recording talking to Dumble and the other officer, explaining how the excuse that the police gave for not investigating it was rubbish because they relied on one witness who said that he didn't hit me, even though we have a statement that of course is whitewashed by Judge Ralton, even though it was in the bundle provided to him in the case, which was obviously the witness statement from Miss Stockdale, and Miss Stockdale actually stated that she saw the male knock into me or make contact with me in some respect. I can't remember the exact quote, but Judge Ralton is relying on the fact that the police refused to investigate the issue, and he's casually dismissing the complaint as if I'm complaining about having been, just a slight bit of rudeness. He thinks it's perfectly acceptable for this man, German or otherwise, to, at the top of his voice, say he's going to chop me up into little pieces. We hear Underwood going on about children being present at the library. Indeed, where he was shouting where the cafe, which is what Miss Stockdale refers to the incident happening on the 5th of February, near the cafe, which is just right next door to the children's version of the library. He's threatening to chop me up into little pieces at the top of his voice, which and you can hear from Judge Ralton's tone that he's not interested in whether this has occurred. It's of no consequence to my emotional state, to my right to be at the library to protest that situation, and indeed he fully supports the ban, as we can see, in the conduct of police to terrorise me from attending the library and addressing the assault on the 5th of February. And he talks about this as some tiny little insignificant detail, when of course he accepts that my detention was lawful on the basis that Underwood qualifies his states that he would have arrested me. I should have read that bit out, but he makes it clear he would have arrested me anyway. But even on the terms that I'd sworn at this female, it may or may not have been justifiable in all the circumstances. But whether it was justifiable or not, it clearly would be if I threatened to chop her up into little pieces, or one of the officers, or anybody else. So, and if I made false allegations when the library was full of witnesses, including Miss Stockdale, then clearly he's accusing me of. If he's saying there's no credit to my complaint, and I was making things up with a room full of witnesses and CCTV camera, then of course he's accusing me of perjury and perverting justice. And if I'm not perverting justice or perjury, then Ralton and Underwood and all the officers are all colluding in the major violence and assault and threats from the man, possibly of German extraction or Northern European extraction, if I'm permitted to define him, and that becomes the issue. This is the issue for Judge Ralton, whether I've described to his potential nationality, than whether or not he's threatening to chop me up right next to a children's area of a public library. Ralton just feels that it's his duty to go on with endless personal attacks by me, and there's no point in my reading them out. He deals with it's all my fault. The conduct between myself and Mr. Dumble is all my fault, all generated by me. It had nothing to do with the events of 5th of February, and Dumble's quite within his rights to walk up to a civilian and tell them that they're not supposed to go into a public area, that they have that by all lawful rights they have to be. Even if I am trespassing, it is a civil matter and not for police to enforce. That is the very definition of the word civil. And of course, civil, if there was an order in place, it would be a different matter. And even if an order was in place, it would be for the courts to prosecute me for breaching the order, not for the police to enforce a civil order. Judge Ralton buries as I say, the main thrust of my grounds of complaint, the issue to do with the perjury, the lies about the fucking ugly bitch, the fabrications, the fact that Underwood, simply the lies is only the tip of the iceberg, because in his witness statement, which I've read out, nowhere does he address when he looked at the footage. The key issue being, when did he look at the footage to put into his MG5 statement, 2 days after the incident, or the following day, to say that the footage had been examined and it only shows post-arrest. None of that he's expecting that. Talalay ignores it in his defence statement, and Underwood denies it in him. It's the key cornerstone of perverting justice, of the malicious and deliberate fabrication, because of course it ties in the fact that he's lying about what the footage shows or what he's examined in the footage. It ties in with the fact that he's concocted the fucking ugly bitch. They're not too entirely. The key evidence that he's perverted justice and lied about the footage is not some trivial little matter to be completely ignored in the essence of the claim in general. Mr. Gray arrived at the library and met the PCSOs outside at about 16:40. The events that occur thereafter take place in a comparatively short time frame. We can observe much of what went on in Mr. Gray's audio-visual footage, and we can hear everything the footage recorded audibly. I tried to reassure Mr. Gray during the trial that I repeat here, that there is no evidence of any fault with the footage other than the audio being out of sync with the video, which is of no consequence. Mr. Gray meets the PCSOs. At this short-lived point in time, he is polite. Mr. Gray identified himself to PCSO Dumble, who tells Mr. Gray that he has met him before. Mr. Gray then makes some mention of how he had been treated previously by the police and demands that PCSO Dumble switch on his body cam. He didn't have a body cam, so I didn't demand that he put it on. I asked him why he wouldn't put it on, wouldn't wear one. PCSO Dumble calmly refused, and the conversation then escalates, with Mr. Gray asking, without justification, given the calm behaviour of the PCSOs, whether he's going to get a walloping. Mr. Gray has alleged, as I referred to Judge Ralton many times, I've been hit and abused by the police and received injuries from them and been assaulted by them, even by their own admission, on many occasions. So I'm not just asking him about the walloping out of the blue. So I continue. Mr. Gray has alleged that PCSO Dumble refused to switch on the camera in order to intimidate Mr. Gray. There is no evidence to support this assertion. The video recording shows calm on the part of PCSO Dumble. It is common ground that PCSO Dumble told Mr. Gray that he had been banned from the library and that he was not allowed in. Mr. Gray said that he took the statement as a police order not to enter. There was no such order. PCSO Dumble told me that he was concerned Mr. Gray would cause a disturbance, and the strategy was to de-escalate the situation, as Mr. Gray had become very heated by now. Mr. Gray does proceed to cause a noisy disturbance outside of the library, as can be seen and heard from the footage. He is verbally very loud. I consider him to be shouting, aggressive, abusive, and insulting to the PCSOs, as anyone can see if they watch and listen to the footage. This is all, even if this was true, and I'm calm, I'm engaging them in conversation, I'm just not agreeing with them, and they're talking over me, and they're not being reasonable because they're not engaging. But in any event, no indication is given what rights these officers have to approach me and be interfering in my private interaction with when there's been no evidence of a criminal offence having occurred. I have no problem with them being there. I have asked for them to attend, but that is to observe and to ensure that peace is kept. When I do enter the library, but they are the ones who are creating the breach of the peace. They're clearly using their uniforms to intimidate, and they're clearly trying to persuade me to do something which I'm fully entitled to do. That is the criminal offence of harassment, definitively. It is by asking someone to try and stop somebody doing something they're entitled to do, or to get them to do something they don't have to do. And they're doing both. And that isn't addressed at all. Mr. Gray challenges the PCSO's authority to stop them going in on the basis that they were not empowered to stop a civil trespass, but they were there to try and stop a disturbance. I set out below some of the things he can be heard shouting. Who's going to stop me? Fascist Nazi. Am I coming into your face? You are not the henchman. Uniform thugs. You look pretty thuggish. Mr. Gray then enters the library. I'm sure most of those things, or many of those things, are said once I'm in the library. I'm sure he's taking the order out of sequence, but I'm not going to bother reliving the ordeal just to prove him wrong. Of course, the footage can be played at any time. You've got it all on the documentary in part one. Mr. Gray then enters the library. The PCSOs do not try to stop him physically. There are staff members of the public in the library in the vicinity of the scene. Mr. Gray continues to verbally abuse the PCSOs, and I set out some more of the things he can be heard to be shouting. Couple of yogs, you creep. Not going to harass or abuse me. I'll be back every day. Only going to resolve through the criminal courts. Nazi outfits, look pretty ugly to me. Thuggish outfits, uneducated, power and stupidity, no O-levels. And no, of course, addressing, which I try to do in the most calmest way, given the stress of the situation, to deal with the issue of the 5th of February attack, and pointing out, getting that officer to act as an independent witness, to say that the grounds for the original officer refusing to investigate the assault with the sports bag and the threats to chop me up, that it was recorded by the officer that they had a witness, or there's some evidence that it couldn't be seen from where that person was, or somebody, I can't remember the exact, that he had seen the person walk past and hadn't hit me. Well, we had Stockdale's evidence that she asserts she did see him make contact, and in any event, I was pointing out that there was two massive computer screens between my side and the guy opposite, so he couldn't possibly have seen what the man had done when he'd gone by with the rucksack, when it was below the eye line of the computers, and I was getting the officer. So of course that is completely excluded. So all again, it's just my reacting to the circumstances of the 5th of February. No swearing can be heard at this time. In this police statement, PCSO Dumble recalls Mr. Gray referring to them as fucking apes, and wrote these words down in his notebook soon after the incident, but this cannot be heard. He and others record Mr. Gray as being red in the face, and Mr. Gray did not challenge this. PCSOs do not have the power to arrest. See, just the main and really only issue is whether I swore. And if I didn't swear, then all the allegations that I did is clearly fabricated. If I'm being loud, as Ralton is pointing out over and over and over again, drawing attention to myself and having clear-cut sound recording, which is not faulted in terms of technical problems by Ralton himself, then why don't we stop there? Why don't we stop with the issue of he didn't hear any swearing, and these officers have sworn under oath that I have effed and blind all over the place, and he ignores that, just as he ignores the attack on the 5th of February as the tiniest little trivial insignificant factor, and then he just moves on about other trivial matters about whether I was red in the face, and then what he says next, which is PCSOs do not have the power to arrest. So what? What's that got to do with whether or not they've lied about the allegation? They call for backup, and Police Sergeant Underwood arrives soon after 16:45. PS Underwood has described Mr. Gray's behaviour, and it appears Mr. Gray takes issue only with the words PS Underwood heard him say. No challenge was taken to PCS Underwood's note that Mr. Gray had his arms in the air, or that there were lots of people of all ages present in the library. Arms in the air? Why would I challenge the officer about if I'm having to? Where are my arms going to be? Down by my side, as though I'm on parade in a military camp. Obviously, my arms are in the air. I'm in a stressful situation. I express myself as most people do by using and communicating with their hands. I do it far less than the French or I, as an English person, do it far less than the French or the Italians do. But having your arms in the air, I'm holding a phone, so a recording device. So I'm having to try and keep that focused. And I'm obviously reliving the trauma of the 5th of February and now being terrorised by officers who from the constabulary who have many times before injured me and assaulted me, which is of no interest to Judge Ralton. Well, he knows fully about it, but he's deliberately and sadistically whitewashing it from the public judgment. So far as other members of the public in the vicinity are concerned, PS Underwood records them in his notebook as being in disbelief and shock. One can see some members of the public and or staff in the footage in the library. A woman appears in the footage. She approaches Mr. Gray. She says words to him to the effect that he was distressing people and should take his argument outside. According to Mr. Gray's footage, he replied in aggressive manner to the woman saying, "Do I want an ugly thing like you coming in my face?" quotation marks. In evidence, Mr. Gray said he used the word ugly to refer to the woman's behaviour rather than appearance. Given that he referred slightly earlier to the PCSO uniform as ugly and use of the words ugly thing like you, I reject Mr. Gray's assertion entirely. I have no doubt Mr. Gray intended to verbally abuse the woman. In any event, it is difficult to see how her behaviour could be described as ugly. Mr. Gray's assertion that the woman should have told the PCSOs or PS Underwood to undertake the argument outside is absurd, as he had no intention of leaving or complying with any request to leave. I cannot see that the woman did or said anything that would objectively cause offence to Mr. Gray, and in my judgment he simply lashed out at her verbally because she dared to ask him to go outside. Well, so Underwood is saying it's perfectly normal. So why don't people walk up to him when he's in the court building and ask him to leave the court building? He goes on, there are other versions of the words said to have been used by Mr. Gray towards the woman. Well, version of the words. Okay, well, see the way he uses stuff, all that he uses, he himself are using words to cloud exactly what needs to be clarified, right, and create more confusion than anything else. So you put one fucking ugly bitch, see PC Parsons, who's Parsons' pocket notebook and PS Underwood's pocket book police statement. Fuck off, as reported to Mr. Wilshire and recorded on the custody record front sheet. When at Patchway police station later, Mr. Gray told police he had told the woman to get her fucking ugly face out of mine. Why any of this is relevant, considering what I've said is relevant, considering all that matters is the footage versus the false allegations or the alleged false allegations against the officers. Mr. Gray was asked why he told the police at Patchway Station that he swore at the woman if he knew that he had not. At first he sought to justify the use of such words in the context of being kidnapped by the police and in the frustration of the moment, but then he said he did so to see the situation when the police would not look at the footage. He said they took the words hook, line and sinker. It became plain that Mr. Gray was seeking to somehow catch out the police by deliberately lying to them to corrupt the available evidence. How on earth, I mean, I've explained that in part one of this documentary, the thinking behind it. Under oath, if the recording of the testimony were to be played back, I would make it clear that I had a confusion of different emotions, different thoughts going through my head at the same time. One wasn't weighed against the other or cancel the other out. There were different motives behind why I was saying what I was saying. I can't remember now specifically whether the word fucking, when I specifically said the F word in the sentence I said to Underwood when I was correcting him, was part of my emotional or fact that he was lying about the fuck off, which is all that Ralton should be concerned about. And even when he points out that the word fuck off was one of the versions of events complained of, that was from Underwood. So he says that Underwood says the fucking ugly bitch, but then he ignores the fact that it was Underwood who'd originally said fuck off, and whether my emotions about the F word was used as an emotional response to that, or a combination of just simply of thinking, well, now I've said it, I'm gonna, or I'll say this to hook them up, or just being sarcastic. It doesn't really matter because I know from the sound recording that I have not sworn in front of the public before being arrested. I have been calm to the female. I have not shouted at her. I have not threatened anybody, including the police, even though they're clearly threatening me. And that should be all that matters. The main incriminating evidence given by Underwood and the various effects, and in the context of the MG5 statement from Underwood that there was no footage of the incident before being arrested. Ralton goes on to state, it is common ground that PS Underwood said oi 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 and threatens to make an arrest. He then took Mr. Gray by the arm before making an arrest. PS Underwood records in his pocket book that he was ushering Mr. Gray from the woman. Mr. Gray shouts, "Fucking get off me," and asks for arrest. Some 25, so I didn't ask for arrest. He's playing with words. I'm in the heated situation that Underwood has grabbed hold of me and not purporting to arrest me. I'm clearly saying either formally arrest me so that you've got there's some justification for grabbing hold of me, or release me. Some 25 seconds after touching Mr. Gray's arm, PS Underwood arrested Mr. Gray for a suspected Section 5 public order offence. It wasn't touching, he grabbed hold of me, he restrained me. So again, Ralton is just simply lying as to everything surrounding the most distressing part of the incident, which is when I'm initially being detained and restrained by Underwood, and the difference between when he arrested me and when he's if he doesn't, it just the Wood v DPP ruling is absolutely as simple as a child could understand. If an officer lays hold of a civilian and doesn't purport to arrest him, he or she is committing the offence of assault. It's not confusing for Ralton to simply define the difference. But anyway, Ralton goes on with his cover-up and lies. Mr. Gray sought to forensically dissect the 25 seconds in order to support his argument that in-law PS Underwood had no authority to touch him, having not made an arrest or intending to make an arrest at that point in time. As a matter of simple fact, the whole episode is seamless. That is utterly untrue. There is a distinction that Underwood himself makes between him saying, if you don't calm down, I will arrest you, at which point he's already grabbed hold of me, and when he says, you're under arrest. If he'd intended to arrest me at the time that he grabbed hold of me, he would have said, you are now under arrest. But there's a whole, what Ralton claims is 25 seconds of time from the moment he's grabbed me, not touched me, but grabbed me and detained me in my liberty, to the moment he's arrested me. And there's a clear piece in the bit in the middle, and I'll play it now, just for avoidance of doubt, to show the exchanges.
Okay. Do I want an ugly thing like you coming in my face? I mean, I've never seen it. Get your fucking hands off me! Get your hands off me! Will I arrest me then? That's what's going to happen. Go on, now arrest me now! No, I'm under arrest. You cannot put your hands on me unless you're arresting me. No, you can't! I know the law backwards. Believe you me. You cannot put your... Okay, you are arrested. Yeah, you're under arrest.
Time, and when he formally arrests me, he'd already spoken several times, so it's not as if he, the excuse that he would need me to, to be quiet before he informed me that he was arresting me or something along those lines, or because I was shouting over him. None of that applied, because I was responding to things that he had said, several things that he had said before he'd arrested me, but after he'd made contact with me. But in any event, it could be seen as largely irrelevant if I'm being falsely arrested anyway, if I'm being effectively kidnapped in terms of the actual grounds of detaining me. Before there is an issue, the custody record records as reason to arrest as follows: to enable the true name and or address of the detainee to be ascertained or verified on the facts of the case, that seemed this case in the fact of this case that seemed justified. Well, no, that is a subsection of Section 24A of PACE. The officer has to originally have reasonable grounds of suspicion that an arrest that an offence is being committed. And so without that reasonable suspicion, the officers can't do anything with me because they don't have the grounds or the legal powers to arrest. There has to be reasonable suspicion that in a civil case has to be proven. They have to prove that they had reasonable suspicion to prove that the arrest, the detention was legally justified. PS Underwood puts handcuffs on Mr. Gray in the rear stack fashion, i.e. Mr. Gray's wrists are bound behind him and he is taken outside. Mr. Gray continues his abusive, aggressive, rude and insulting shouting. PS Underwood describes trying to search Mr. Gray, PC Ings telling Mr. Gray to calm down, Mr. Gray lunging and PS Underwood manhandling Mr. Gray, such as to put himself between Mr. Gray and PC Ings, such that one of PC Underwood's legs was between Mr. Gray's legs, straddling him. It is this incident to which Mr. Gray refers as the sexual assault. He complains he could feel PS Underwood's groin, and in oral evidence it seems that the reference to groin meant genitals. P.S. Underwood denied that his genitals made contact with Mr. Gray and denied that there was anything sexual going on. Mr. Gray is then taken in the police car to Patchway Police Station. The cuffs are removed at Patchway Police Station. Processing of Mr. Gray commences at 17:40, and Mr. Gray complains of indentations caused by the cuffs in the skin of his wrists. There is no evidence of any injury. The detention log records events at the station and shows that Mr. Gray is not cooperative. Mr. Gray is detailed until he is charged and released on police bail at about 19:29. Not cooperative. I couldn't be more cooperative. I provided what by any criteria was effectively incriminating evidence, stating that I had used the F word, or implying, or maybe insinuating that I had used the F word in the presence of the female, and therefore supported to some extent the allegation of a Section 5 public order offence. So it is recorded. It is correct to observe that during the detention, no police officer sought to view the footage taken on Mr. Gray's device. There is dispute about whether the footage could have been viewed on the device itself or by connection to a computer, but no attempt was made. Mr. Gray fairly makes the point that if the footage had been viewed and listened to, the words he actually said would have been heard. The record that the footage only showed post-arrest would appear to be wrong. Well, what kind of help is that, Judge Ralton? Because he's supposed to be assessing the allegation in my claim that he lied about that. He wasn't wrong. It wasn't just wrong. It was knowingly wrong. And clearly at some stage, not only was the footage, the content of the footage made known to the police, if only at the criminal trial proceedings, but certainly for the purposes of the civil proceedings in front of Judge Ralton, and his own observation that the footage no swearing can be heard in terms of myself before arrest, and therefore he's not addressing the clear fabrication from Underwood. Indeed, he's contradicting Underwood's comment in the MG5. The MG5 states that it did show some of the incident, but only post-arrest, which means that it must have been viewed. If Underwood did not view the footage, then he's clearly lied in the MG5 to say what was on the footage. So from every angle Ralton comes at it, the amount of wicked, premeditated corruption and lies from this judge, exploiting the fact that he has been entrusted at huge public expense to weigh the merits of one of the most serious allegations that can be made against a police officer, such as perverting justice, lying to incriminate a member of the British public. And he's addressing that by simply lying after lie after lie, even on every single issue surrounding the incriminating comments from Underwood. As stated, there's no way around it that Ralton can deal with without having to lie his head off as to deal with both the initial comments. He doesn't deal specifically with the fact that Underwood has changed, made the initial fuck off allegation and then changed that to fucking ugly bitch. And then in his formal sworn statement that I repeatedly swore and cursed prior to my arrest, all the way through the incident, he says, or consistently through the incident, when I do not swear even once. And then he lies to say that he has examined the footage, and then so Ralton has to simply fabricate a scenario where the officer has said he didn't look at the footage at all. Well, he did say he looked at the footage. It's clear in his witness statement, in the MG5 statement that he has sworn. The CPS reviewed the file in advance of the court hearing to take place on the 19th of September 2015 and informed the police on the 24th of June 2015 that the library staff witnesses did not want to give evidence and the case would proceed on police evidence only. The trial became before District Judge Taylor and Mr. Gray was found not guilty. Mr. Gray told me that the case was thrown out on the basis of no case to answer and that no evidence was given. The unapproved note of the judgment of District Judge Taylor suggests that evidence was given. For the avoidance of any doubt, I make my own findings of fact in this case, and I did not rely on that note. Well, you have to laugh, because if Judge Ralton, he entertained that it was possible that Mr. Talalay, Robert Talalay, was correct, and that the matter had gone to full trial and not been dismissed at the halfway stage of no case to answer, bearing in mind the police were very, very lucky that they were not prosecuted for perverting justice and perjury, given the footage clearly proved I did not use the F word, I did not call the female a bitch, I did not shout at her, I did not raise my voice to her, and all this incriminating evidence was heinous criminal wrongdoing of the first order. And yet Judge Ralton believed that Judge Taylor would have been so corrupt, because he's presumably just assumes rightly that Judge Taylor is as corrupt as Judge Ralton is, and would have just continued. Well, I'm still not content that you didn't say call the woman a fucking ugly bitch. I'm not content that these officers aren't lying. I still want to hear it from Mr. Gray under oath. You know, having played the footage over and over and over again, have Judge Ralton having confirmed that the footage proves I didn't say the damning evidence, and Judge Ralton is scratching his head and saying, well, maybe it would be perfectly normal for Mr. Talalay's version of events to be correct, and for the criminal trial judge to waste more public money time on trying to secure a conviction against me by having to give under oath evidence about me not saying the words I was accused of saying, having played the footage over and over again of not saying them. It is pure Alice in Wonderland. So viewers, I'm sure you're as sick and tired of these issues and the evidence as I am, or at least I hope you are, if you're human beings and you care about the justice system at all. We've waded through Judge Ralton's endless forays into completely irrelevant issues, and we're finally coming at the end of towards the end of the judgment and the video to the key issues actually finally being addressed, most of which this is only 1/3 of the judgment is actually concentrated on the legal issues surrounding whether I was being lawfully detained and whether there were reasonable suspicions and whether Underwood sexually assaulted me. We've had to digress into endless rubbish about my relationship with the inanimate object, namely a library, as though any evidence was given before Judge Ralton about my relationship with the library. Clearly, any of the issues surrounding the 5th of February or generally with the library staff, Ralton cannot comment at all unless he personally knows, which is quite possible given he's a local resident of Bristol, personally knows the witnesses such as they were, but they weren't called as witnesses before the trial, and therefore he hasn't got any evidence to make any unbiased or accurate assessment of whether I'm in the wrong, or in the general sense, not obviously in the issue of the 10th of February, but in the general sense, even in terms of the ban. All Ralton knows about the ban is that the police have not investigated it. I've made very serious allegations, and indeed Ralton himself makes it clear he couldn't give a stuff whether someone's threatening to chop up another member of the public. He's more concerned about the fact that I've referred to him as a German than he is about the fact that whoever this man was or wherever he was from, he was threatening to chop me up into pieces. And I even had a witness statement that was produced by Robert Talalay, by the Chief Constable's legal team, from Miss Stockdale, who made it quite clear that she had witnessed some sort of physical contact, or indicated. She's not that clear, but what difference does it make if the police have refused to investigate it? And what Ralton is doing is simply taking that issue as simply evidence of my reacting to it, is therefore evidence that I'm some kind of wrong and it's all my fault and I've just gone there to create trouble. This is what he's about to conclude. Once I've read out the final bit of the judgment, I'll sum up. And my case against Judge Ralton is that he's guilty as sin in terms of misconduct in judicial or public office. That is the official title of the offence in Archbold, certainly 2015 edition. And there's clear authority that judges can be convicted and hopefully sent down for abuse of public office. The ruling of R.B. Bembridge and the ruling of R.B. Llewellyn-Jones are both case law, common law issues, common law cases in which judges for the misconduct in the office as judges have been convicted and punished. And of course, so it's just for you as the viewers to assess, because no senior court, because they're in the pockets of Judge Ralton, and indeed Judge Ralton to a large extent is acting for the senior judiciary, such as Judge Warby, Judge William Davis, and the ones that I've mentioned in this video and other videos. So the only jury and the only judges has to be the public that these judges are supposed to be serving. And clearly, where there's any violence that is unfolding in the Central Library, any evidence that judge is colluding in that violence and colluding in the kidnap of members of the British public generally, then clearly everybody is at risk. Everybody is threatened by such criminal misconduct. I'm sorry if I have to spell that out. I know it should be obvious, and that is, of course, why we have criminal offences or misconduct in public office, in order to preserve and safeguard everybody from the potential tyranny of corrupt judges running amok. I have to say it because, among other things, if you go to my mission statement documentary, for instance, or introduction video, you will see that the official judicial website that is published by the government or the Ministry of Justice have stated that the judges are immune from prosecution for their conduct while sitting as judges in public office. That is completely and utterly fabricated, and it shows you the extent of corruption and villainy within and kowtowing within the mass media, that they allow this complete fabrication generally, let alone the conduct of judges like Ralton and the other judges pertinent to my videos. But even the basic fact of whether judges can be tried and convicted and prosecuted, obviously, for misconduct for their conduct as judges while sitting in office. They are not immune. That is complete fabrication. It's obviously self-serving, because the press powers that be clearly are directed and governed and puppets of the judges, assuming no judges were actually involved in the publication of the assertion that they are immune. But it suits their purposes to be immune. That means they can do what they like as judges, and obviously that by definition they're saying they could murder someone in the middle of a trial, order someone to be executed during a hearing, get up to all sorts of God knows what with other members of staff, for instance. And be completely immune. That's complete nonsense. They can't simply take out a gun and shoot somebody and say, well, I'm immune. And that's obviously an extreme example. And of course, my example is the extent to which, and have been guns involved in, pointed at me from police or used to intimidate me in some of my other documentaries. If they are effectively doing that by lying and conniving in such issues as attempted murder and sexual assault and kidnapping, as I'm alleging in this and other documentaries, then it makes no difference whether they might as well be able to take out a gun and shoot people they don't like, or because of their race, or because they're upset with them, because they're immune from prosecution. And clearly, in any event, although it's it hardly needs to be said that it's a ridiculous proposition anyway, it's not true. There is findings up until the 1960s where judges have been convicted for misconduct in public office. So that needs to be clarified anyway at some point. So the video is worthwhile just to address that one point. But obviously that is my case against Judge Ralton, and once I've read out the final bit of the most relevant or only relevant part of the judgment, I'll get on with setting out my case that this man and those associated with this case should be prosecuted for the offences. And obviously the ball is then in your court as the public and any press watching, etc., to see where that ends up. So paragraph 76, I've skipped out. I mean, the previous couple of paragraphs, Judge, page after page of going into, or basically what's called pettifogging. He's just outlining section 24 of PACE, the Criminal Evidence Act, and then going into every single word of the PACE Act. The only relevant issue, I said 24A pace in the earlier part of this documentary. I meant to say 24 of pace, not 24A. 24A of pace is citizens' powers of arrest under pace. But the judge really doesn't need to spell out every single word or iterate every single word of the Pace Act, of 24 of pace, and 28 of pace as well. He's gone into all that matters. It is the cornerstone of my case that Underwood has fabricated evidence in order to justify having reasonable grounds of suspicion that I've committed a Section 5 public order offence. And the issue is that I was arrested on the specific words, fucking ugly bitch. That was the final case in the, if you remember, the MG5 summing up as the prosecution, as the grounds for prosecution. So whatever evidence that Underwood gave before or since is largely irrelevant to what he actually said was the grounds of charging me and arresting me in the first place. Albeit we know, although Judge Ralton has whitewashed, the original allegation of telling the female to fuck off was completely altered anyway. So was the evidence fabricated? Well, the video proves that it was. And therefore there were no reasonable grounds of suspicion. Therefore, any other issue surrounding other matters under 24 of pace is irrelevant. Anything under 28 of pace, God knows, I haven't even bothered to check what 28 of pace actually refers to, because how do we get onto Adam rating 28 of pace when the defence hasn't even got to stage 1, which was the reasonable grounds of suspicion versus the fabricated evidence to create the reasonable grounds of suspicion, which obviously meant there were no reasonable grounds in the first place. So waffling on page after page, as Judge Ralton has done with the pettifogging of the particular subsections of 24 pace and 28 pace, and itemizing exactly what section 5 of the Public Order Act states, etc. He then addresses in a case reference, of none of which, of course, is referred to by Talalay. So this is where it's supposed to be the judge standing back and being neutral, and the other parties have to do their research and do the grunt work and make submissions and bring up legal points and try and get out on technicalities and so forth. In this case, even though I'm unrepresented and Robert Talalay is a £5,000 an hour barrister, or £500 an hour, whatever he charges, the judge has stepped in and weighed in on behalf of Robert Talalay to do all the grunt work in terms of the legal issues, all the legal issues, as I've said, including Castorina v. the Chief Constable of Surrey Court of Appeal, 10th of June 1988, Wolf, Lord Justice, identified 3 questions to be asked, which I summarise as follows. Did the arresting officer suspect that the person who was arrested was guilty of the offence? The answer to this question depends entirely on the findings of fact as to the officer's state of mind. 2, assuming the officer had the necessary suspicion, was there reasonable cause for that suspicion? This is a purely objective requirement to be determined by the judge if necessary on the facts found by a jury. 3, was the decision to arrest reasonable? Well, I mean, surely the 2 and 3 is answered by the fact that the video proves I didn't say the words that I was accused of saying. That surely should be the end of it. But Judge Ralton, of course, just makes the point that is self-evident anyway. He doesn't even need. Why does he have to need to refer to an obscure Castorina v. etc. when he just has to go on 24 of pace? Was there reasonable grounds or not? Was it reasonable to arrest me on the allegation that I had called the female a fucking ugly bitch, when the sound recording proves that I did not say those words? That's all that needs to be determined in terms of the fabricated evidence. Of course, and then as further to support of that is Underwood's fabrication that he had viewed the footage and it didn't show, it only showed post-arrest, i.e. it didn't show whether or not I swore at the female, which was itself fabrication, which is completely ignored and whitewashed by Ralton. Having heard the evidence of PS Underwood and Mr. Gray, and in particular having viewed and listened to the footage at the library, A, on the balance of probability, Mr. Gray did not swear at the woman. B, Mr. Gray used the words, "Do I want an ugly thing like you coming in my face?" C, PS Underwood's recollection of Mr. Gray swearing at the woman is incorrect, but understandable in the context of the melee created by Mr. Gray. The words were obviously abusive, especially in the context of Mr. Gray's behaviour, which was obviously disorderly. It would have been reasonable to suspect that members of the public within earshot of Mr. Gray would have been distressed by his words and behaviour. The mistaken belief that Mr. Gray swore at the woman was not the sole reason for the arrest. I accept PS Underwood's evidence that he would have arrested Mr. Gray in any event for a Section 5 Public Order Act 1986 offence. The arrest is consistent with the way Mr. Gray was behaving in the library, and thus, in my judgment, the Castorina criteria are made out. Accordingly, I find the arrest was lawful. Mr. Gray refers to 3 assaults, as he perceives them to be, namely, PS Underwood taking hold of his arm prior to arrest, the sexual assault, and handcuffs assault. In this case, I see no need to separate out the torts of assault or battery or trespass to the person. There is no separate tort of sexual assault. An assault is uninvited physical contact. No injury is required. Once uninvited physical contact is established by the claimant, the defendant is liable unless he has a statutory or common law defence. Mr. Gray refers to Wood v. DPP 2008 EWHC 1056. That case is authority for the proposition that a police officer is guilty of assault if he restrains someone without arresting him or intending to arrest him at that point, even if the arrest would have been justified. However, on the facts of Wood, there is a clear disconnect between the assault and the arrest of the sergeant in that as the sergeant in that case did not consider that he was entitled to arrest Mr. Wood when he first laid hands on him. Thus, Mr. Wood was able to succeed in his defence of self-defence. I have described the incident starting with Mr. Gray's verbal abuse of the woman and ending with his arrest as seamless, and I'm satisfied that PS Underwood did intend to arrest Mr. Gray. I'm just going to pause on that statement just to iterate. We'll play again, just for one final time, the brief exchange between myself and Underwood when he twice he says he makes it clear he's not at that time arresting me when I challenge him about whether he's allowed to restrain me without purporting to arrest me. And he clearly denies, he makes it clear from his own lips that he is refusing, that he's not arresting me at that time. If your behaviour continues, those are the words that are whitewashed by this liar, Judge Ralton. If your behaviour continues, then you'll be arrested after he's grabbed hold of me.
Okay. Do I want an ugly thing like you coming in my face? Wait, I've never seen it. Get your fucking hands off me. Get your hands off me. Get arrested, will I arrest me then? That's what's going to happen if you go. No, arrest me now. No, am I under arrest? You cannot put your hands on me unless you're arresting me. No, you can't. I know the law backwards. Believe you me. You cannot put your... Okay, you are arrested. Yeah, you're under arrest.
And clearly on the footage. And clearly, again, just more glaring evidence of the fabrications from Underwood just being echoed, the fabrications being echoed and repeated and then embellished by Judge Ralton, the liar for hire. And we go on bearing in mind, these aren't even details that Robert Talalay provided in his original defence before Judge Ralton got involved. Having heard that, we'll go on. Mr. Talalay relies on Section 3 of the Criminal Law Act 1967, which reads as follows. A person may use such force as is reasonable in the circumstances in the prevention of crime or in effecting or assisting in the lawful arrest of offenders or suspected offenders or of lawful persons or of persons unlawfully at large. Section 117 of the Police and Criminal Evidence Act 1984 would appear to duplicate that power in the circumstances of the case. Mr. Talalay relies further on PC Underwood seeking to protect members of the public from Mr. Gray. Mr. Talalay took me to Ashley v. Chief Constable of Sussex Police, Sherwood, intervening 2008 1AC with respect to the defence of self-defence and civil law to a claim of assault. Lord Foscott approved the following test. The necessity to take action in response to an attack or imminent attack must be judged on the facts as the defendant honestly believed them to be, whether or not he was mistaken. But if he is mistaken on fact, he can rely on the fact only if the mistake was a reasonable one for him to have made. Given Mr. Gray's escalating behaviour, that was reasonable, especially after his verbal abuse to the woman. Well, the mind boggles. I'm now disorderly conduct insofar as what am I doing? I'm arguing with police officers in a library. That is the extent of it. I call the woman an ugly. I say I do not want the ugly woman in my face. That is, I'm perfectly entitled to express an opinion. It doesn't come within a million miles of escalating to threats of violence or imminent attacks. The imminent attack is an outrageous and wicked assertion that somebody can be detained just for simply expressing an opinion. And there's no suggestion, there was no evidence from this female. So obviously, what on earth, whatever was on the mind of the female clearly wasn't to the extent that she would even give evidence to the police about that matter. And there was I was interacting with the police, not any members of the library staff or any of the library users. The recordings clearly prove that, and it was the officers that engaged with me. I did not engage with them. They came up to me, which was what I was perfectly happy at that time for them to be present in case of a public order issue. But they're the ones who say that I'm not allowed to enter the library, or say that I'm banned, as though that is the part of the job description when it isn't. And the engagement continues with them. I'm expressing an opinion, but obviously, if that is evidence of somebody engaged in an attack or imminent attack, then anybody who's involved in any kind of argument, any kind of dispute with any person comes within that criteria. Just to kind of give this pretense that there's some sort of neutrality and fairness and compliance with the law, Judge Ralton goes on to say, however, I do not accept that PS Underwood can defend the assault on the basis that he was using reasonable force to eject Mr. Gray from the library as a trespasser, per Porter v. the Commissioner of Police for the Metropolis, 20th of October 1999. Whilst that case is undoubtedly authority for the proposition that police can assist in the ejection of a trespasser, that is not why P.S. Underwood used any force in this case. So he's called Underwood a liar, at least in respect to that. He ignores the glaring lies surrounding fucking ugly bitch and the fabrication in the MG5 that he'd watched the video and it didn't show the incident, the part of the incident that was important. But Underwood has lied, but that's fine if he's lied about that issue. Of course, this has gone through a lawyer, so it's not Underwood that's lying. He can't. If Underwood's been permitted by his barrister Robert Talalay to advance his proposition, it's Robert Talalay who's at fault, not Underwood, because Underwood clearly has not been properly advised if he's giving grounds of restraining me that do not comply with the law that is being relied on. Porter v. Commissioner of Police, the powers to involve trespass, to use force and trespass has to be through an inspector. There has to be some sort of paperwork involved where an inspector gives permission. A sergeant can't just on the face of it, in any situation and start enforcing trespass, which is a civil matter. By completeness, I address the matter of sexual assault. For completeness, so right at the end, by the way, let's deal with the complaint of sexual assault, having forced Mr. Gray to relive having the genitals, and Underwood absolutely openly in the proceedings, because there's no press present. Mr. Gray's on his own, he's unrepresented, and Judge Ralton's in his pocket. And he was almost boasting about the fact that he accepted that I would have felt his testicles for a good 2 minutes against my leg or his genitals, contradicting his earlier evidence that bizarrely that he would have straddled my leg, not even admitting, or only halfway admitting that he had straddled me in his response to the complaint from Baisley, or the complaint that was investigated in quotation marks but not investigated by Baisley, when he addressed the issue in the paperwork before trial in his witness statements. The matter's just denied outright by Talalay in his defence statement. That there was any contact, but he came into court. There's no press around. Nobody cares about this case. Nobody cares about Mr. Gray. Judge Ralton is as corrupt as the day is long. Yeah, I did straddle you for a good 2 minutes, and it is almost certainly that you felt my genitals against your leg whilst you were pressed back against a car with your hands behind in restraints. And there was nothing sexual about it, but I did do the conduct that was disputed in any way, shape or form, as described. That's what Talalay said, denied the allegation as described or at all, but then Underwood came in and admitted it quite openly. But this is how Ralton deals with that complaint. I inquired of Mr. Talalay and Mr. Gray what made an assault sexual, and it seems that one has to look at the criminal law and Section 1.3 of the Sexual Offences Act 2003. I'll just put that up on the screen so I can move on, and you can peruse that at your leisure. If we don't know what a sexual assault is, we're in deep trouble, are we not, viewers? But the judge has to clarify the law. I mean, the only issue was, did this officer, well, whilst I was being straddled by this officer, was I even being legally detained? And even if I was being legally detained, was it not assault or sexual assault or unreasonable force? Was it unreasonable force at all? That isn't addressed by Ralton at all, because that's obviously an assault even if I was being lawfully detained. On what basis could it possibly not be an assault for this officer to truss me up in rear-stack handcuffs, so the fact that there were indentations that were visible by the time I was in custody, and push me against cars, and straddle me and keep me in handcuffs until I'm released from them in front of PS Wilshire about an hour later, can't possibly be reasonable force to find out my identity, which was the main reason for the arrest, and because I had called somebody names which I hadn't even called them. So even if I'd called the lady an effing ugly bitch, it surely would not have qualified such a huge degree of force. And in so much that I was struggling or resisting, well, which came first? The use of force. Obviously it was the use of force, which I am entitled to resist, even if it's unreasonable, even if I'm being lawfully detained, which I clearly wasn't. I find that Mr. Gary's allegation that PS Underwood committed a sexual assault is absurd. There was no evidence at all of any intent on the part of PS Underwood to cause, permit, or allow his genitals to come into contact with Mr. Gray's leg. No reasonable person would consider any such contact in this case as sexual at all. So he's not even making a clear finding about whether or not contact was made. This issue, I've now been complaining about this issue in at least one PSD investigation that was dealt with by Baisley, some of the paperwork you've seen there, and in which Underwood does not clarify whether contact was made for any period of time, and indeed denies it outright. He then lies about his denial and admits it in trial, having when the defence was made by Talalay at huge public expense, addressing the specific issue of sexual assault, he doesn't clarify whether contact was made at all. And when it finally gets to trial, Underwood's extremely candid about contact being made for a good 2 minutes. She totally accepted that. Transcripts will prove that. They're on record. It's a recorded proceeding, so they can be obtained, for a very small amount, because it's only a couple of lines, where he admitted that the contact had been made for a good couple of minutes. So viewers, this is obviously the final paragraph, and it just about sums up the extent of Ralton's torture, collusion, and wicked conduct in these proceedings. First of all, he doesn't make it clear whether he is or is not stating that somebody who's putting their genitals, the groin area, pressed against somebody else's body, especially the upper part of their thigh, which is where Underwood was placing his groin as alleged, is not sexual. He seems to be implying that whether or not it's deliberate, and he hasn't made any findings that Underwood about what physical contact Underwood admitted to in trial, and for how long, and what were the circumstances of that physical contact. In a tussle, it is quite conceivable that some genital contact would be, albeit through clothes, would be made with somebody that is being tussled with. I was not accused of resisting arrest. I was not accused of assaulting Ings. Ings gave no evidence. And in any event, there were 3 officers present, so that any form of restraining me or needing to restrain for me may have involved some sort of brief contact by Underwood for a second or two. It cannot have been for 2 minutes, as he admitted, possibly even longer, that he was holding me in that bent back against the car when there were 2 other officers present, that there was no other way of restraining me that did not involve him straddling my legs, so that I consciously now, for the rest of my life, have his genitals pressed against my thigh. Not only that, but I have to relive it over and over again, even at trial. Even there's been no proper investigation into it until trial. There's no mention of the fact that Underwood denied any contact, that the defence statement that said there was no contact, that the allegation of contact was denied as alleged or at all. That was Talalay's position. There's no mention that Underwood has flip-flopped any on all of that, and no specifics about what Underwood was admitting to, which was in trial he admitted to straddling my legs, that contact would have almost certainly been made for a couple of minutes, and that was the specific key evidence. And Underwood just whitewashes any mention of the details, but yet makes me psychologically relive that abuse in the most sadistic and torturous way. And I mentioned the offence of misconduct in judicial or public office is also a criminal offence under Section 134 of the Criminal Justice Act 1980 or 1988. It'll come up on the screen. But in any event, for any public official to psychologically or physically torture a subject of England or Wales or the United Kingdom, or certainly of this country, and that is clearly what Judge Ralton is doing. He's psychologically torturing me, making me relive the most graphic and horrible experience, one of the most graphic, or much worse than the twisting of cuffs, which I'm quite used to. I'm almost immune to it in some senses because it happens so often. I've been scarred permanently by the torturous use of handcuffs, in which Ralton was also colluding and involved, and obviously that's for another video. But the sexual element to their abuse, because this is now the method of choice. What they would have done, obviously, in the 50s or the 60s, somebody that was running around with allegations or evidence that those in high office are basically worse than the perjurers and perverters of justice and perverts that they are locking up, which is what my campaigns are about, would sort of meet with the terrible fate of falling downstairs, or certainly getting a massive drubbing in a police cell. But of course, with CCTV cameras everywhere, and mass social media and so forth, they tend to shy away from that kind of step. They obviously haven't with me, because they've CS sprayed me repeatedly, and you've seen all the injuries, or some of the injuries I've received, just some of the injuries I've received from the police in the last 20 years since I moved to this godforsaken city, Bristol. And the only way in which it was arguably not torture was the fact that I could have just simply withdrew from the case entirely and not progress through the proceedings, which of course would have delighted Judge Ralton and Robert Talalay and all concerned. Perhaps not Robert Talalay, because of course he made a 20 grand. Would have probably delighted everybody but Robert Talalay. Obviously there's two issues there. First of all, I'm never going to not relive these incidents anyway until I get justice. So this is obviously why I've had to relive them again for the purposes of this video. And secondly, I'm trying to orchestrate a independent criminal investigation into all these matters that I've raised with Judge Ralton. Here, what Ralton's agenda is to prevent any kind of criminal investigation and lie his head off in every conceivable way where he's not whitewashing, in order to collude in the very offences that he should ordinarily be referring on to an independent police force. So that obviously is the best place to finish on, where Judge Ralton's utter whitewash, utter collusion in the whole issue surrounding the genital contact with myself for a good couple of minutes. Judge Ralton makes it clear he's not even going to specify whether he's actually saying that deliberately putting genitals on somebody's body even amounts to a sexual act at all, or evidence of prima facie evidence, which is all he has to look at, prima facie evidence of a sexual assault. If in my particular circumstances, he's not even going to detail to what extent Underwood admitted to the contact and the evidence that he was doing it deliberately, and he had no justification for that sort of prolonged contact between his genitals and forced contact between his genitals and my body, quite near my own genitals, but certainly pressed against my upper thigh. If somebody's making an allegation of that sort, manifestly, the least they can expect in this civilized country, law-abiding, law-upholding country, is some specific details about what Underwood has actually admitted in the proceedings before Judge Ralton.